There are undertakings that were made on Tuesday's hearing to allow time for us to return back this morning to deal with that. And therefore, I welcome you again to the 80th day of the hearing on this Motukea Commission of Inquiry. But without further ado, I now call upon our counsel to take us through this morning. Thank you, counsel.
Please, the Commission. Commissioner, as you are aware, this morning's purposes are for Curtin Brothers and Balimore number 39 to make their submissions. And Commissioner, without any further ado, they've given us copies of their submissions, which I note are quite voluminous. So, and they've indicated that they might require the whole day. So we won't waste any time. I'll ask Mr. Vartimus to enter his appearance and probably get right into it. Thank you.
Thank you, counsel.
Thank you, Counsel Assistant Commissioner. I announce my appearance. I appear for Curtin Brothers Holdings NG Limited and Balimore number 39 Limited with my learned friends Mr. D. Wood, Mr. Al Igori, if the Commission pleases. And as was indicated, the matter is listed for submissions today on behalf of my clients, and we're ready to proceed with the submissions if the Commissioner is ready to take them.
Thank you, counsel. You can proceed with that.
Thank you, Commissioner. Commissioner, the submissions are made today on the basis and in reliance on the earlier undertaking given by Counsel Assisting that they will be providing and making submissions Friday the 31st of March 2023 and on other undertakings and assurances given by Counsel Assisting. We have prepared to assist the Commission firstly detailed written submissions with schedules that carefully evaluate the evidence and have references to where that evidence is to be found, e.g. by reference to exhibit numbers and pages of exhibit numbers. We've also prepared to assist the Commission a working bundle of documents that has an index of the documents enclosed. And if I could ask Mr. Vori to provide to your associate, Mr. Commissioner, a copy of the written submissions and a copy of the bundle of documents, and I could briefly just do an introductory explanation.
Thank you, counsel.
And as Mr. Kipper said, we've already provided copies to Counsel Assisting, so we've already provided individual copies to both Counsel Assisting of both the documents that have been provided, in addition to the copy for you, Mr. Commissioner. Mr. Commissioner, could I just explain in terms of the documentation? You'll see that the first document is entitled Commission of Inquiry into the Sale and Purchase of Motukea Wharf, Submissions on behalf of Curtin Brothers Holdings NG Limited and Balimore number 39 Limited. You should have that document, and it has a table of contents at the front.
Yes.
Have you identified that document? Yes, thank you. And the second volume that's given to you is a working bundle of documents, as I indicated. If you have a quick look at that bundle, you will see that it has in front of it an index to the bundle of documents, which have tab numbers and are paginated.
Yes.
You have that document with the index. Just by way of clarification, and we've explained this to Counsel Assisting, all the documents in the bundle are already in evidence. They're exhibits before the Commission. And that's apparent if you have a look at the index to that bundle, you'll see that the documents have tab numbers 1 through, consecutively to 15. And they have in the second column the exhibit number where you can find those documents.
Yes.
In the index to the bundle, you'll see the second column of the index has the exhibit numbers.
Yes.
And it has page numbers where you can find the documents in the bundle. As I indicated, all those documents are already in evidence. I should just indicate that obviously not all the documents referred to in the submissions are included in the bundle, but for ease of reference, we've included some of them. For example, we've included the affidavit of Gabriel Michael and the statement of Romney Killipat and valuations of Deloitte and Ernst & Young and some NEC decisions, etc. But that just makes it easier for you, Mr Commissioner, we hope, that you don't have to go looking in the exhibit list to find various documents. But I just reiterate that they're not the only documents that we refer to or are relevant, but some of them. Before I commence with the written submissions, could I just have an introduction? And that's this. Mr Commissioner, you've quite correctly, with respect, observed during the course of this inquiry, which is now sitting for its 80th day, that firstly, the Commission must afford natural justice and procedural fairness. Secondly, that the Commission must confine itself to the terms of reference and not stray beyond the terms of reference. And thirdly, the Commission must properly evaluate all the evidence, our emphasis on evaluating all of the evidence. Those observations made by you during the course of this inquiry on countless times are obviously, with respect, patently correct. Non-observance of any one of those matters would constitute in our submission a serious error of law and compromise the integrity and validity of any report. So it's critical with respect that the observations that you made, Mr Commissioner, are now applied in the context of writing the report and properly evaluating all the evidence. As part of the legal requirement, of course, to provide natural justice and procedural fairness, the Commission is required to provide what the case authorities say, including the Supreme Court, Papua New Guinea, quote, good, proper and sufficient reasons for any finding or recommendations. This also entails, as we submit when we take you to the submissions, careful consideration and reliance on our detailed submissions and the arguments we make in them, and an evaluation of those submissions and arguments. We now invite you to have a look at the written submissions. If I could invite you to take up the written submissions, and if I could briefly take you to the table of contents at the beginning of the written submissions. So you'll see from the table of contents at the front, Mr Commissioner, of the submissions.
Yes.
Yeah, the table of contents. You will see broadly that we've categorised different areas that need to be considered by the Commission. We've done a general overview, which I'll take you to, and then we've dealt with such things as the benefits of the purchase of Motukea, the Prime Minister's evidence in Part 7, Mr Gabriel's evidence in Part 8, that no adverse findings should be made in Part 11, and we've dealt with the chronology of various matters in Annexure 1 and a schedule of exhibits which have and have not been provided in Annexure 2. Could I invite you to now turn to page 2 of the submissions, Mr Commissioner, the overview.
Yes.
What we have done in these submissions is attempted to assist the Commission by not only making submissions on various issues, but making reference to the exhibit numbers and references in the evidence to assist the Commission because, as you correctly said, one needs to evaluate all the evidence, and it's not sufficient to simply write a report that doesn't cross-reference the actual evidence and a proper analysis and forensic examination of the evidence. So when you read our submissions, you'll see in the footnotes that we've put references to where there is support for the particular proposition or finding of fact. So you'll see in footnote 1, we've made a reference to the port sale agreement and where you can find it. If you turn to page 3, we've made a reference in footnote 2 to the transcript and the day of the transcript and the page number of the transcript. So everything is properly sourced. So it makes it hopefully helpful for you, Mr Commissioner, when writing the report, and also being able to justify that there is evidence to back up the submission, not just a submission without any backup. So it's important that if you need to see a source of our submission as to a fact or proposition of law, you'll see the footnotes. And on that point, you'll see, for example, when you go through the submissions, that if you turn to page 11, for example, if I could invite you, Mr. Commissioner, to turn to page 11.
Yes.
You will see footnotes 20 to 25 reference various case authorities. So if we make a proposition of law, the state of Papua New Guinea to acquire Motukea was made after very extensive consideration by the National Executive Council and committees established by it over many years, with the benefit of... In paragraph 3 of our submissions, we make the observation that the decision by the state to acquire Motukea was made after extensive consideration by the National Executive Council and committees established by it over many years, with the benefit of numerous independent studies and expert advice. We detail that in considerable detail in section 4 of these submissions, where there will be footnotes as to where you find the references. But could I just pause here, Mr. Commissioner? In approaching your task of writing the report, it is of course critical that you have an open mind in writing it and properly evaluate all the evidence. Unfortunately, many, particularly from overseas, are unfairly critical of Papua New Guinea and the system of government and decision-making. It is a positive if this commission were to find, as we submit that it should find, that the proper processes were followed in relation to the sale and purchase of the Motukea Wharf. That is a positive. There should not be any preconceived idea or pressure or expectation, often driven by overseas influence or preconceived ideas, that there is anything wrong with what has happened in relation to this transaction. What the evidence demonstrates is that it was way back in 1998, Mr. Commissioner, that the NEC approved in principle the development of a new port and directed the Harbours Board to conduct necessary studies and report its findings. In 1999, a detailed independent expert feasibility study identified potential sites, including Motukea. From that time, there were numerous independent reports that were prepared, consultants were engaged, and the NEC deliberated on the decision in relation to the relocation of the port and the establishment of a new port over many years, over many decisions. And that is apparent from paragraph 3 of our submissions. The evidence also establishes that there were significant benefits to the state of PNG in purchasing Motukea, and we address that in paragraph 4 of our submissions, Mr. Commissioner. If I could invite you to look at paragraph 4 of the submissions on page 3.
Yes.
The evidence establishes the impact of the benefits on the future economic growth of PNG and its citizens is and was profound and far-reaching. The evidence establishes, as we detail considerably in section 5 of the submissions, that firstly, prior to the acquisition of Motukea, it was obvious from an economic and social perspective that the location of the port in downtown Port Moresby was untenable and had to be relocated. That was because, amongst other reasons identified by various experts and those involved, that the port had low capacity and slow vessel clearing time, was causing traffic jams, which everyone was aware of that ever drove past it, and shutdowns in the central business district. And there was a lack of available land in the CBD that was required for the expansion, so that it was held that moving the port out of the CBD eased traffic congestion and obvious other pollution, enabled future port growth, and provided an opportunity for an urban renewal of the CBD, which has eventuated. Secondly, as set out in 4B, Motukea represented the only possibility of relocating the port to a suitable pre-existing facility and was therefore the fastest possible avenue and the most efficient manner to relocate the port. Motukea at the time was tried and tested as an international port. Other options would require 7 to 8 years of construction of a new port and at a much higher cost. That's what the evidence establishes. And proper evaluation and proper examination on the statement and make sure that that guides us to the finality of this Commission of Inquiry. In paragraph 6, we make the observation that natural justice and procedural fairness compel you as the decision maker to take into account all relevant considerations in making the decision, and accordingly and consistently with the requirements of natural justice, in properly evaluating and examining Mr Michael's evidence and when making findings or recommendations, the Commission is required to take into account all relevant considerations, including all the relevant evidence and arguments raised in these submissions. Failure to take into account all relevant considerations would, in our respectful opinion, clearly constitute a serious error of law and compromise the integrity and validity of any report. It's the issue of the 4 possible potential adverse findings as indicated by counsel assisting. We say they should not be made, and this is just the overview, and we deal with it comprehensively in other parts of the submission, so this is just the overview. This is because the first and second potential adverse findings are to the effect that Curtin Brothers and Balimore did not obtain nor rely upon any independent valuation of Motukea. This potential finding is misconceived. Curtin Brothers was never the owner of the property that is the subject of the COI, but the possible finding goes along the misconception, we think, and the mistaken belief that Curtin Brothers was the owner of the property when it was not. There was never a requirement, legislative, contractual or otherwise, for Curtin Brothers or Balimore to obtain or rely upon any independent valuation of Motukea. And if we just pause and use common sense here and your experience, Mr Commissioner, if someone is looking at selling a property, they're not compelled to get a valuation. They have to decide whether they want to sell the property, and they can decide on the terms of the sale, which include critically the price at which the property will be sold, how quickly they want the settlement to proceed. So, Mr Commissioner, just want to check that you can still hear me because the video seems to have frozen. Can you still hear me, Commissioner?
Yes, I'm following.
Thank you, Mr Commissioner. So if you're, Mr Commissioner, looking at selling a property, you're not under any obligation to get a valuation of the property. You just have to decide that you want to sell the property and the key terms, including the price. Even the purchaser hasn't got an obligation to obtain a valuation. Valuations are often obtained by purchasers simply because they need finance and they need to obtain a valuation to give it to the financier to provide the funds. In B, we make the observation that the third potential adverse finding of any pressure is erroneous. Mr Michael's evidence is contradicted by Mr Kitterpat's evidence, is not credible and should not be relied upon. And we set out in extensive detail why Mr Michael's evidence is not credible, and in fact it's internally contradictory. He internally contradicts and conflicts with parts of his evidence to other parts of his evidence. In 7C, we make the observation that the fourth potential adverse finding must be considered with extreme caution, having regard to the potential prejudice of the COI making such a recommendation. So the cases say that before you make any adverse finding or recommendation, you have to have regard to the gravity or seriousness of the recommendation. And the more serious the recommendation or finding, the more cogent the evidence one has to find to justify it. The fourth potential adverse finding is based upon the first 3 potential adverse findings and rests solely on the evidence of Mr Michael, which on proper evaluation and analysis is completely discredited, including by he himself. In D7D, we make the observation that Mr Michael's evidence was not credible. It can't be relied upon. As a valuer general, on his own evidence, he signed, sealed with his official seal, and certified as true and correct a valuation report which he now says was false, and also falsely certified it was signed on an incorrect date. Because when we take you to it, the two reports that he was prepared are both dated the 23rd of September 2014, when on his own evidence, his own sworn evidence, he did not sign both valuations on the date that he certifies they were signed. When properly evaluated with other contradictory evidence, including his own, it does not provide what the cases say is required, namely clear and cogent proof required to make the potential finding. As we say, his evidence will be analysed in great detail in Section 8 of these submissions. It is critical that the COI take into account all relevant evidence and address that in its reports. The cases say it's not sufficient for a commissioner or a judge simply to say Mr X gave evidence, he wasn't cross-examined, and I accept his evidence. That's an error of law. One has to evaluate all the evidence, including his evidence and other evidence. And as I've said, the authorities say one has to have clear and cogent evidence, particularly when serious findings or recommendations are being considered. In paragraph 8, we make the observation that the evidence before the Commission establishes that due and proper legal and administrative processes were followed, and that the PNG people have greatly benefited from the acquisition of the Motukea Wharf. And in fact, we refer later on to the legal clearance certificate given by the Solicitor General, confirming that all legal requirements were satisfied and the matter could proceed to ultimate sale. In paragraph 9, we make the observation that the Prime Minister, the Honourable Prime Minister's evidence supports such a finding, as prior to the state entering into the port sale agreement, Prime Minister Marape, as a member of the NEC and as then Finance Minister, who was involved in the transaction, firstly considered that Motukea had the necessary wharf infrastructures in place, and we refer there as an example to footnote 3, and you can see that at that exhibit number and tab 2, page 9 of the working bundle for reinforcement to justify that finding. The second thing is that the Prime Minister, as a member of the NEC and NEC, was impressed by Curtin Brothers' offer to sell Motukea. Thirdly, in June and July 2014, which was before the valuation by the Valuer General, had already made the decision to realise the sale of Motukea, including initially approving a purchase price of PJK 750 million and then approving the port sale agreement and the sale price of 725 million. NEC was satisfied on the material they had that it justified a purchase price of up to 750 million. The evidence establishes that they negotiated the price down. Originally, a figure of 800 million was suggested, and then ultimately a figure of 725 million was arrived at. In 9A, we note that the NEC documents established that the purchase of Motukea was, quote, key to the economic interests of the state and the development of Port Moresby. Mr Commissioner, in paragraph 10 we make the submission that at the hearing on the 21st of March, the Commissioner raised the question, quote, how do you contest the apparent contradictions, if any, in this situation if there is no cross-examination that is to take place? That related to the evidence of Mr Michael. To assist the Commissioner, we address in our submission the evidence of Mr Gabriel Michael in extensive detail, forensically analysing his evidence as you will be required to do, against not only other parts of his evidence, but the totality of the evidence before the Commission that is relevant to his evidence. including Mr. Killerpat's evidence, of course. Counsel assisting is bound by the particulars and is not entitled to make submissions outside the limitations provided by the particulars as to any possible adverse findings, as it would constitute a denial of natural justice and procedural fairness if that was to be done. Mr. Commissioner, as we say in paragraph 11, you correctly identified that there are contradictions between the evidence of Mr. Michael and other evidence before the Commission, including Mr. Killerpat. Importantly, there are also contradictions within Mr. Michael's own evidence. The fact that a witness is not cross-examined does not, as a matter of law, and should not, as a matter of law, mean that his evidence or her evidence must be accepted on face value or without question, or that the relevant tribunal, in this case the Commission, only needs to consider his evidence superficially and without question. We emphasise two important points in paragraph 12 and 13 of our submission. Where a witness is not cross-examined, which would include Mr. Killerpat, for example, not just Mr. Michael, the evidence should be rejected and not relied on if it is, for example, unreliable, contradicted by other evidence, or other circumstances support its rejection. Notwithstanding that a witness is not cross-examined, a proper evaluation and examination is still required of not only the evidence given by the person making the affidavit, but all the other evidence properly before the Commission which relates to that evidence. In short, and this is very basic, in short, a false or unreliable statement contained in an affidavit does not magically become true or reliable because the person making the affidavit is not cross-examined. Such a statement remains false or unreliable. Such a statement must remain false or unreliable. The mere failure to cross-examination or decision not to cross-examine doesn't alter the truth or reliability of the statement. That truth or reliability needs to be evaluated by reference to not only that person's evidence and the likelihood of that evidence being true or false, but by the evidence of others, in this case Mr. Killerpat, and in this case evidence given by Mr. Michael himself that completely contradicts and undermines his credibility. We say in paragraph 13 that when a proper evaluation and examination of Mr. Michael's evidence is conducted, not some cursory examination, together with the other possible evidence before the COI, the COI should find that Mr. Michael's evidence was not credible, is contradicted by other evidence and should not be relied upon. We address that in detail in section 8 of these submissions, but we just here give a few examples of many as to why Mr. Michael's evidence is not credible, is contradicted by other evidence and should not be relied upon. They are set out in paragraph 13 of our submissions. They include, firstly in A, on Mr. Michael's own evidence, he signed, sealed and certified, Mr. Commissioner, that his valuation of Motukea at approximately $722 million was correct, but he now also alleges under oath, contradictory to his certification and signature, that this approximately $722 million valuation was false, demonstrating that on his own evidence alone, he is a witness who is prepared to act dishonestly and he cannot be regarded as a credible and reliable witness. In 13B of our submission, which Mr. Guerrero should have been provided a copy of, Mr. Michael alleges that he produced the allegedly approximate $722 million valuation because he was in fear of imminent disciplinary action or losing his job as Valuer General. This allegation is contradicted by Mr. Killerpat's evidence, who denies any such discussions with Mr. Michael and confirmed correctly that there was no way he could have been disciplined or lost his job as alleged. In C, Mr. Michael has not produced, pursuant to the summons served upon him, documents that support, confirm or verify his alleged version of critical conversations. If we pause there, he was served with the summons. He was required to produce diary notes, documents relevant to this issue. He produced none. He would have you, Mr. Commissioner, try and believe that he had this serious conversation that put him under this so-called pressure, and he had certified a valuation and then certifies a contradictory valuation, and he makes no diary note to verify that. He sends no email, he sends no letter, he reports to no one about it, not one single person. He says in his affidavit, quite unbelievably, that he had one conversation with Mr. Killapat, he has a phone call from Mr. McGann, he has one meeting with Mr. McGann, he feels under pressure, he changes his certification, and he says he has no further contact with anyone in relation to sale and purchase of the wharf. No further conversation. He has no diary note, no complaint made about it, no record of any email, not one thing to justify his position. Mr. Commissioner, on proper evaluation of his evidence, one could not trust the evidence of Mr. Michael. It is inherently contradictory. His evidence is totally unbelievable. And we will assess that in great detail and show his contradictions. But could I say this in relation to one of his contradictions? In September 2014, he produces a valuation certified by him, but not just certified, Mr. Commissioner, signed by him, signed under seal, a very important act, under seal of the Valuer General. But in March 2015, when he says he's had no contact with Mr. McGann since September the year before, he produces an other valuation in relation to other land where he values that other land based and relying upon the 722 million valuation. The 722 million valuation was relied on by the Valuer General in March 2015 to certify an other valuation, and he certified that the 722 million valuation was able to be relied upon as accurate information as a basis for further information. Now, if the Valuer General honestly believed that the 722 million valuation was false, he could not credibly say that in circumstances where in March 2015 he relied on that valuation to support a valuation of another property in which he signed, certified as correct. It's just untenable, Mr. Commissioner. It cannot be accepted on any proper evaluation of his evidence. And when you write the report, Mr. Commissioner, consistent with the case authority, it's important that you evaluate his entire evidence and you set out our arguments, and deal with our arguments on the evaluation of the evidence. Mr. Commissioner, in D, we say that on proper examination and evaluation of all the evidence, it is apparent that the valuation of Motukea at 722 million was prepared contrary to Mr. Michael's evidence prior to his conflicting valuation of 418 million. And this is why, Mr. Commissioner, you were completely correct when you reiterated on many occasions that there needs to be a proper evaluation of the evidence and not some cursory, quick, superficial examination on the evidence. Because when you compare, and we'll take you to it, when you compare the two valuations, it's apparent that it's quite false. It's quite false of Mr. Michael to give evidence that the 418 million valuation was prepared before the 722. Because when you carefully look at the evidence and forensically examine the evidence, we will take you to it. But the 722 valuation, which he says was prepared second in time, does not have typographical errors. It turns out that he used a word processor, obviously, to change the figure from 722 to 418. But he says the 722 was prepared second. But we say the 418 million valuation was prepared after the 722 million valuation, because not only does the 418 million valuation changed the figure, but it's fixed some errors, some typographical errors that were in the earlier valuation. If someone doesn't change a valuation after the first valuation, and then all of a sudden, we'll take you on it. We'll take you, Commissioner, to see the evidence, but you'll see that it's completely contradictory to what he says about the order of the evidence. Importantly, in 13E, despite the extensive material produced to the Commission, no one has produced the 418 million valuation. We say that in 13E. The 722 million valuation is produced in the documentation, but not the 418. The first time the 418 valuation appears anywhere is when he produces his affidavit to the Commission many years after September 2014. Many years after. We point out in 13F, which I've made the point, that Mr Michael relied on the 722 million valuation and, using his words, as a very good comparable, end of words, when valuing the Port Moresby Downtown Wharf in March 2015, indicating that he did not consider the 722 million valuation to be false or inaccurate. That is, why did he, and this lacks credibility, if he says that the 418 million valuation was false in September 2014, why did he, when he certified and sealed a valuation in March 2015, see that it was appropriate to rely on the 722 million value when valuing another property? If he was being honest to you, Mr Commissioner, if he was being frank to you, Mr Commissioner, he would have relied on the 418 million figure when he did the valuation for another property in terms of a comparative in March 2015, but he didn't. He said that it was appropriate to rely on 722 million valuation as, quote, a very good comparable, end of quote. In 13G, when valuing the Port Moresby Downtown Wharf in March 2015, Mr Michael not only signed but he sealed the report and certified that the statements and information in the report were true and correct, which included a reliance on a value of 722 million for the Motukea Wharf. So, Mr Commissioner, they are just some examples, and we'll give many more examples of why, on proper evaluating Mr Michael's evidence, he has no credibility and his evidence cannot be relied upon. In paragraph 14, we make the observation that Mr Michael's summons was discharged on the understanding, with counsel assisting, confirmed before the Commission, that even though he was not cross-examined, it should in no way be taken that Mr Michael's evidence should be accepted as correct, and that contrary, we indicated that it would be submitted that his evidence was unreliable and not credible, and we now do so. In paragraph 15, we observed that there has been no adverse conduct by Balimore or Curtin Brothers, and no such findings can be properly made on any proper and fair evaluation of the evidence. And we emphasise fair evaluation because, consistent with the authorities, they say that if any adverse findings are to be made, the cogency and probity and reliability of the evidence has to lift to another level, a much higher level. Adopting the words of the Prime Minister as then Finance Minister by reference to the NEC decisions, we point out in paragraph 16 that it was considered that Motukea was, quote, key to the economic interests of the state and the development of Port Moresby. And the state and the members of NEC should be encouraged for their foresight in deciding to relocate the wharf with the significant benefits attributable to it. In section 2 on page 8, we deal with Balimore's participation in the Commission of Inquiry, and we will assure Mr Commissioner that you'll read these submissions a number of times, so we don't intend to go through in any detail part 2 in relation to our participation. It's fair to say that Curtin Brothers and Balimore have been cooperating with the Commission. Extensive documentation was produced to the Commission. We have complied with the directions of the Commission, and we have sought to assist the Commission with respect, not the least of which is the provision of these written submissions. We now turn to part 3 of the submissions on page 11. If I could invite you to turn to page 11, Mr. Commissioner.
Yes.
Paragraph 37. There is no doubt, and it's not contested, that the Commission of Inquiry must afford natural justice and ensure procedural fairness. And there are many instances of cases on that. And there are cases where natural justice and procedural fairness has not been afforded, and Commissions of Inquiry reports have been successfully challenged or aspects of them. In paragraph 38, and this is important, and it's a summary of the position, the established notions of procedural fairness must be given explicit recognition and practically applied by the Commission with respect to any findings it makes. The Papua New Guinea Supreme Court has made plain that the requirements of natural justice are based on fundamental constitutional protections. That is, there's an enshrining in the Constitution of these requirements of natural justice and procedural fairness. And the content of these procedural rights include, firstly, the rule that the person making a finding, in this case you, Mr. Commissioner, in the exercise of your jurisdiction, must base your decision upon evidence that has some probative value. That is, carries some weight, has some strength, not some weak evidence. Secondly, the rule that the person making a finding must listen fairly to any relevant evidence conflicting with the finding and any rational argument against the finding that a person represented at the inquiry whose interests may be adversely affected by it may wish to place before him. So we're placing before you by these submissions references to the evidence to suggest that there are rational arguments as to why Mr. Michael's evidence should not be accepted and that there should be no adverse findings accordingly. In C, the cases say that what is required is that the decision to make the finding must be based on some material that tends to logically to show the existence of facts consistent with the finding, and the reasoning supportive of the finding, if it be disclosed, is not logically self-contradictory. If I just pause there, the example of Mr. Michael, who in September 2014 says that one valuation which he certified, can you still hear me, Mr. Commissioner?
Yes, I'm listening.
That one valuation which is certified was false, another valuation which is certified was correct, but then 6 months later certify in a third valuation, a different valuation for different property, that the 722 million valuation effectively was correct, contradicts the notion that the 418 million valuation was false. Sorry, the 722 million valuation was false. In 38D, we make the submission that taking into account all relevant considerations in making your decision consistently with the requirements of natural justice and in proper evaluating the evidence of Mr. Michael, no recommendations should be made as suggested by counsel Sisting. Could I pause there with respect not to overstate the position that counsel Sisting put in his letter? Counsel Sisting did not say that adverse findings should be made. What he said was that it may be open to the possibility of certain adverse findings made. That, of course, is a different point. So the fact that counsel Sisting has written it is not submitting that those adverse findings should be made. He's saying that there's a possibility that they may be open. But that possibility must depend on a proper evaluation of the evidence. And the purpose of that letter was to give us an opportunity to respond to possible adverse findings, which we could do by these submissions based on a proper evaluation of the evidence. And in E, the cases support the proposition that there must be good, proper and sufficient reasons. On page 12 of our submission, we set out in more detail the law in relation to giving good, proper and sufficient reasons. And of course, the Supreme Court in Papua New Guinea, as we say in paragraph 39, has said that it's an integral part of the duty to accord natural justice that you must give good, proper and sufficient reasons. And in 40A, we point out that that requires the Commission to demonstrate that a person's detailed submissions, in this case our submissions, have been properly considered, not simply saying we have considered the submissions of council and of this view. One needs to have a detailed analysis of our submissions, and the Commission is required to deal with substantial points which we have raised, as we say in 40 sub B, including findings on material questions of fact that led to the making of any adverse findings. We of course say there should not be any adverse findings based on a proper analysis of all the evidence. And importantly, in 40C, the authorities say that the decision must expose the reasons for resolving critical points that are in contest, and the cases say a bald statement on an ultimate conclusion, even by reference to the evidence said to support it, is unlikely to be sufficient. The basis of the decision and the extent to which the arguments have been understood and accepted must be able to be understood by reading any report. In paragraph 41, we refer to an authority which is very useful in crystallising the issue. It says, it is not appropriate for a trial judge, and this principle would apply similarly to a commission. It is not appropriate for a trial judge merely to set out the evidence adduced by one side, then the evidence adduced by another, and then assert that having seen and heard the witnesses, he or she prefers or believes the evidence of one and not the other. If that were the law, many cases could be resolved at the end of the evidence simply by the judge saying, I believe Mr X but not Mr Y, and judgment follows accordingly. That is not the way our legal system operates, and it would not be in accordance with natural justice. In the second paragraph, the court said, it is incumbent upon trial judges, which would be the same as the Commission, to resolve the sub-issues and to explain by reference to the relevant facts the conclusions to which they have come. This having been done, they should then turn to the ultimate facts in issue and explain how their decisions on the sub-issues have assisted them in forming a conclusion on the ultimate issue. We have sought to assist the Commission by a detailed analysis of the evidence and references to the evidence by way of footnotes. So with respect, the task of the Commission has been made much easier and of Council assisting, because we have justified the submission by reference to a proper evaluation of the evidence, which is sourced by reference to footnotes. In paragraph 42, we make the submission that where Mr Michael's evidence is the only evidence relied upon in respect to potential adverse findings, and given the seriousness and gravity of those potential findings, the Commission inquiry must, in its reasons, firstly, address and analyse all the arguments raised in these submissions, not just some, particularly section 8, regarding the potential adverse findings. Secondly, must explain the basis of deciding whether to make any finding by reference to the evidence and other material on which the decision is based. And thirdly, in relation to any aspect of Mr Michael's evidence, particularly given his own and other evidence which contradicts his evidence, address why a particular aspect of Mr Michael's evidence should be accepted or relied upon, if indeed that is the view of the Commission, notwithstanding the arguments in these submissions, or found to not be a sufficient basis for making any potential finding, including addressing the submissions made about that aspect of the evidence. 43, we make the observation that any failure of the Commission to provide good, proper and sufficient reasons will be a denial of natural justice and would constitute a serious error of law and compromise the integrity of the report. In paragraph 44 and following, we deal with the COA's practice note and acknowledgements by Council assisting. You can read that in due course, Mr Commissioner, but it's clear that you issued a practice note, and we say in summary that the practice note is consistent with requirements to provide natural justice and procedural fairness. We now move to page 15 of the submission, paragraph 48, under the heading Failures to afford natural justice and procedural fairness. And again, you can read those paragraphs 48 to, or 48 in due course, but we set out a number of concerns in relation to natural justice and procedural fairness that we raised, which should be taken into account. On page 18, we now turn to the process by the state to acquire Motukea, paragraph 49. You have paragraph 49, Your Honour. Oh, sorry, Mr Commissioner.
Yes.
Paragraph 49. In relation to the process, which is one issue that's relevant to your report, there doesn't seem to be any controversy. This is page 18, paragraph 49 of the submission. There doesn't appear to be any controversy on the matter set out in paragraph 49 of our submissions. It's quite clear that the consideration of whether to acquire the property was based on extensive consideration by the NEC and committees established over many years, and it was based on the benefit and with the benefit of numerous expert studies, independent reports and other expert advice. And we set that out in paragraph 49 to assist the Commission in detail, which you can read in due course. But this comes back to the point, Mr Commissioner, that I said at the outset. It's somewhat unfortunate, particularly from outside sources, outside Papua New Guinea, that sadly, often Papua New Guinea and the system is unfairly criticised. In this case, a proper examination and evaluation of material demonstrates that proper processes were followed. This was not a rushed purchase. This was a purchase that commenced in terms of possible thought in 1998, when the government approved in principle for the development of a new port. And it took many years to come to fruition. It took a lot of investigations, it took a lot of independent reports, and it took detailed consideration of Cabinet. And to that extent, the governments of the day who were involved in the decision should be applauded for the process that was followed. This was not a rushed decision. It was a carefully considered decision. It was a negotiated purchase. It was a negotiated purchase over many years, eventually to bring the price down, to get to an agreed figure by NEC, endorsed by NEC, at $725 million. And legal clearances and other processes were followed. You will see from the documentation that often there were requests for more information, more investigation, and that was complied with. So to that extent, the process worked. The process worked over a number of years. In paragraph page 21, Mr Commissioner, if I could invite you to look at page 21, we deal with the benefits of the purchase of Motukea. And there were significant benefits to the state of Papua New Guinea in purchasing Motukea. Could we just mention some of them? Prior to the acquisition of Motukea, it was obvious that from an economic and social perspective, the location of the port was untenable and had to be relocated. We set that out in 52A. These included things as the clearing time for vessels was slow due to low capacity, the traffic jams, the port precinct reaching operational capacity. In 52B, we make the observation that moving the port out of the congested Port Moresby downtown area would enhance the efficiency and effectiveness of important port operations, but easing traffic congestions, it would alleviate capacity constraints to enable the port growth, thereby bringing about increased efficiencies. It would improve logistical function for importers and exporters. In C, on page 22, Motukea represented the only possibility of relocating the port to a pre-existing facility, and Motukea represented a very plausible and realistic option. If I could stop there, there are many reports from early on that identified Motukea as an appropriate site to relocate for obvious reasons. In E, given the fact that Motukea Island already had sufficient infrastructure in place, etc. So if you look through all of those matters in 52, we extensively deal with the benefits of acquiring Motukea, and you can read that in your own time, Mr Commissioner, in due course. But it's uncontested and obvious that there were major benefits to Port Moresby and Papua New Guinea and trade by relocating. In 53, we also deal with benefits that were acknowledged by PNG Ports in annual reports since the acquisition. If you turn to page 23, Mr Commissioner, and look at paragraph 53, in more recent annual reports, the Chairman's statement stated that, quote, the move to Motukea marks the dawn of a new era, one with modernisation and progress at heart. That's the bottom of page 23. And then on the top of page 24, the annual reports record the Motukea facility project commenced in May 2016. Works undertaken on the Motukea International Terminal was completed this year to meet the demand of the country's growing economy. Port Moresby Wharf was handed over to government in 2018 Asia Pacific Economic Cooperation related activities. And could we just stop here? This was not just a domestic port, this was an international port. This was an international port required for major trade and commerce. So one would expect that the price paid for such a port would be not of a small amount, but would be of considerable magnitude. Importantly, in 53C, the annual report records over the 5-year period, PNG Ports Corporation recorded its highest net profit after tax of $346 million in 2015. This was largely as a result of the gain realised on the Motukea port transaction that year. In paragraph 54, we make the observation that the 2019 annual report of Kumul Consolidated Holdings records that in 2019, PNG Ports Corporation recorded an increase in revenue, overall cargo volume and net profit. In section, I should say that other ports were looked at in terms of investigating possible ports, but in the end, after extensive investigation, reports, feasibility studies, it was decided that Motukea had significant benefits and that Motukea was the preferred site and the site that should be adopted. So there were other sites that were looked at. It wasn't just Motukea, but it was decided quite correctly for a number of good reasons that Motukea was the best option. And that is borne out by the Ports Authority's profit and loss statements and reports subsequently, where they acknowledged a massive increase in profitability, etc. The benefits of Motukea, which are clearly established by the evidence, are relevant to the valuation of Motukea, of course. If the Commission accepts these profound and far-reaching benefits, and it should, because there is no evidence that Motukea was anything other than important, beneficial and nation-building, a nation-building purchased by PNG, then accepting those benefits supports a higher valuation of Motukea. And in fact, when we turn to the valuations, Mr Commissioner, the valuation of Ernst & Young and Deloitte acknowledged that there were benefits in relation to the acquisition of the port land beyond just looking cosmetically at their assessment of value, that one had to add in components to what they classified as, quote, strategic value. There was a strategic value to acquiring this land, and that's referable and supported by the many benefits attributed to the land. Now, on page 25, paragraph 56, we deal with the factual context of the sale of the Motukea Wharf, and there should be no contest in relation to that. You'll see in paragraph 56, we deal with way back to a 1998 decision, which was the starting point of the possibility of moving the port and finding another location. So it went back way back to 1998. Then we deal subsequently in chronological order, Mr Commissioner, date order, various key decisions or context in relation to the sale. And in due course, you can read through that, Mr Commissioner. We won't read through that, but you can see it. Paragraph 57, we deal with initial interest and involvement of the Honourable Powers Parkoff back in 2010. And then if you flick through the pages, Mr Commissioner, on page 26, if I just take you to the headings, page 26, there was an NED decision that's referred to in paragraph 58 of our submissions in 2012. There was a report prepared in 2012, referred to in paragraph 59 of our submission. Then you'll see, and we do invite you to have a look at it, at paragraph 62 of our submissions. If I could invite you to look at paragraph 62, you'll see that there were initial negotiations and valuations in 2013. So that on the 7th of June 2013, Sir Mick Curtin, who you're probably aware is unfortunately deceased, Sir Mick Curtin is deceased, sent a letter to Dr Webster, Chairman of IPBC, making an offer for the sale of part of Motukea for the purposes of relocation. And at that time, a price of 800 million kina was indicated back in 2013. Then you'll see, Mr Commissioner, of events that transpired after that. In paragraph 67, you'll see there's a reference to an October 2013 decision, NEC decision, and you can read that in due course. Then in paragraph 68, we referred to the policy submission, number 264 of 2013, which you can read in due course. If I take you to paragraph 32 of the submissions, you'll see in B4 at the bottom of page 32, B4, it says state team. Do you have that reference?
Yes.
Commissioner?
Yes.
You'll see that it was proposed that a state team be established with responsibility for the expeditious evaluation of Motukea as a site, etc. And of course, various bodies of state teams were established, and the process was followed, due process. Then on page 33, I want to emphasise in paragraph 71, on the 12th of December, Sir Mick Curtin received a letter from the then Chief Secretary to Government making an offer of 700 million for the purchase of part of Motukea. So you can see that what happened was it went from initially 800 million offer by the late Sir Mick Curtin to an offer of 700 million for part of Motukea in 2013. And then in paragraph 72, there were further negotiations. And on 18th of December, Sir Mick Curtin sent a letter in response to the letter from the Chief Secretary. And in paragraph 73, we set out some of the contents of the letter. But the letter said, as we say in G, offered the sale of an increased portion of Motukea land to the state for the port relocation at a discounted price of 750 million. Of course, that was not the final price. Then in paragraph 75, on the 24th of December, the first draft of the port sale agreement, PSA stands for Port Sale Agreement, was emailed by Balimore to IPBC. The draft contract relevantly provided that it had a purchase price of 750 million. Then, in paragraph 76, we refer to the January 2014 NEC decision. Now, this is important. So in January 2014, you'll see from paragraph 76, Mr Commissioner, that the NEC approved the purchase price of 750 million, however, for the possibility of further reduction through negotiation. So they had approved 750 million in 2014, which of course is well before any valuations by the Valuer General, because as it transpired, NEC had the benefit of the valuations of Ernst & Young and Deloitte at an early stage, much earlier than the valuation of the Valuer General. Then you'll see in paragraph 17, 77 on page 36, referred to a policy submission of NEC on the 22nd of January 2014, and you'll see on you can read that in due course, but we want to highlight one aspect of it. If I could turn to page 38, Mr Commissioner, and invite you to look at page 38.
Yes.
you'll see paragraph 20, which says valuation. So in this document that went to Cabinet, it provided that, quote, experts were engaged to separately undertake valuations of Motukea Port. As such, consultants were able to provide some guidance on the costs of infrastructure. However, some issues with key assumptions has meant that the adjustments have had to be made. Furthermore, they deferred business and strategic value to be settled during the process of negotiation. Taking both reports, which I should pause there was the Deloitte's reports and the Ernst & Young report, on balance and providing some estimate of strategic value, IPBC advises that negotiations can start at 700 million kina. So at that point in time, it was acknowledged that there were other valuations, but they were a starting point in terms of valuations because they didn't take into account the strategic value. And it's evident from what we've submitted previously that there was considerable strategic value in acquiring a port which had already been tried and tested and had other benefits. So at that very early stage, 700 million was considered as the starting point for negotiations. Also in that document, on page 38, paragraph 25, the NEC document provided, therefore it is recommended that negotiations for sale of Motukea Port with Curtin Brothers with due regard to an amount of 700 million should commence as soon as possible. Then we invite you to turn to page 39, paragraph 79. There were further negotiations in early 2014 where a letter was written by Sir Mick Curtin, and it stated, amongst other things, and we've underlined it, I have agreed in good faith to reduce the base sale price for a portion of Motukea Island from 750 million to PGK 725 million. Promptly 2 days later, a response was received as set out in paragraph 80 on page 39. Do you have paragraph 80, Mr Commissioner?
Yes.
Page 39. On 12th of February, Sir Mick Curtin received a response from Dr Webster acknowledging the reduction in the price and stating, quote, the Port Moresby Port Relocation Project is an urgent national interest, and I acknowledge and thank you for your consideration to reduce the price further to 725 million, and also take note that the other conditions stated in your earlier letter remain unchanged. Then there was an NEC decision, Mr Commissioner, in June 2014, referred to in paragraph 82, where on the 18th of June, there was a decision to approve the execution of the port sale agreement. And, as set out in paragraph 83, there was a policy submission that related to it that provided, as set out at the bottom of page 40, that IPC was successful in further reducing the purchase price to 725 million. The port sale agreement was also negotiated and concluded with the final purchase price of 725 million. So, Mr Commissioner, you can see from the history that this was not a rushed transaction. The dates are all set out there, the evidence is before the Commission, and this was a carefully considered decision by the members of the National Executive Council and others involved after getting reports, feasibility studies, etc., to acquire this property, and the purchase price was negotiated down from 800 million to eventually a much lower figure of 725 million. This was not a transaction or a contract that was just signed overnight. It was not a deal that just happened in someone's mind and rushed. That is apparent from the documentation, Mr Commissioner, and it's apparent from a proper and careful analysis of all the evidence. And we set out furthermore at page 41 and following further decisions that have been made and were made by the NEC in relation to the purchase and requests for various approvals. You can see, for example, on page 41 we deal with the various state solicitor letters Then on page 42, we deal with the NEC decision of July 2014. Then we deal on page 44 with a request for ICCC approval. If you see page 44, and ICCC approval for the transaction was provided. Eventually there was approval by the ICCC for this transaction. On page 91, you will see that there was an important letter written by Dr. Billy Minoka, CEO and Commissioner of the ICCC. The letter referred to, amongst other things, and we invite you to look at paragraph 49, relocation of the current PNG port site to Motukea is an exercise done in the national interest/public interest. This was an acquisition in the national and public interest in relation to an international port of considerable significance and importance to the people of Papua New Guinea and trade and commerce within Papua New Guinea and externally. The letter also noted, if we look at page 46, that the development and the spin-off economic and social benefits that will emanate from it will be substantial. Mr. Commissioner, I think I may have dropped out.
Yeah, we have an audio problem.
Can you hear me, Mr. Commissioner?
I
I can't see the inquiry.
We should be all right.
I think it's better. Okay, Mr. Chris, you can hear me now?
Yeah, I can hear you. Thank you.
Yeah, thank you, Mr. Commissioner. If I can invite you to look at page 46, Mr. Commissioner, page 46 at the top.
Yes, proceed.
The letter also stated the development and spin-off of economic and social benefits that will emanate from it will be substantial not only for this particular area of Port Moresby and the surrounding areas of the city and local communities, but also for PNG's standing as a country. Then, above paragraph 92, we deal with the August and September letter of intent and addendums, and you can read that in due course, but it's important to note in paragraph 98 that the letter of intent provided, as we set out in 98D, the contract price is $725 million. And in paragraph 99, there was an amended draft of the port sale agreement received around September 2014, and that provided a purchase price of $725 million for an area of 63.53 hectares. You can see then, Mr. Commissioner, we deal on page 48 with the September 2014 ICCC determination. And then we deal with unconditional ICCC determination on paragraph 106, and you'll just see that we follow through the process of what transpired in relation to various documents. Importantly, we want to draw this to your attention on page 49, Mr. Commissioner, that there was an environmental impact statement that was done, and that's referred to at paragraph 112 of our submissions. And the impact study was extensive and it consisted of over 1,000 pages in relation to the Motukea relocation project, and it was provided to the Department of Environment and Conservation. The environmental impact study, importantly, as we set out in D, acknowledged that the relocation to the project site supports a range of municipal and national planning visions for Papua New Guinea and Port Moresby, and in E, the relocation would allow an expanded port facility to be used for the collective benefit of all. Also on page 51, we note that it was recorded that the Motukea site was assessed to be the preferred site based on environmental, social, technical and economic considerations. Do you see that reference, Mr. Commissioner, on page 51, item I? We've
Yes.
underlined it. Page 51, I.
Yes.
The Motukea site was assessed to be preferred site based on environmental, social, technical and economic considerations. And you can find that reference in the footnote 157 if you look at Exhibit KCH 96 at pages 4 and 5. The report concluded, as we set out in J, amongst other things, very importantly, Mr Commissioner, in J3, that the relocation of Motukea offers a deep water site able to support port expansion and economic development needs while offering additional benefits to the wider Port Moresby area through the development potential for the port land and the CBD to commercial and residential purposes. It is little wonder, with respect, based on all the assessments, feasibility studies, reports, etc., and common sense, why the NEC found in their wisdom that it was appropriate to purchase this very valuable land, which was critical for the future development of Papua New Guinea. And they should be applauded with respect for the vision of doing so. On page 52, we deal with land title dealings, and you can read that in due course. But I wanted to emphasise, move forward to February 2015, Mr Commissioner. If I could invite you to look at page 53 of the submissions, please.
Yes.
In February 2015, particularly paragraph 119 and 120, in February 2015, the State Solicitor provided legal clearance for the port sale agreement. And we quote his letter of the 25th of February 2015, where the State Solicitor issued his legal clearance and rendering the PSA to be legally effective in a letter signed by him with respect with the subject, quote, legal clearance / Motukea Port Sale Agreement. And the last paragraph of his letter, which is very important, states this, and it was bolded by him. The rest of the letter was not bolded, but he bolded this part of his legal clearance. And he said this, pursuant to my powers under section 13B, and this is set out in paragraph 120 of our submission, of the Attorney General's Act, Amendment Act 2013, and as approved and advised by NEC in its decision number 194 of 2014, I hereby issue my legal clearance rendering the port sales agreement to be legally effective and parties can forthwith implement its terms accordingly. And it was in the context of a letter with the subject legal clearance Motukea Port Sale Agreement. So the legal clearance was given, and subsequent to that, certain events occurred, including payments of deposits, etc. And that's set out in paragraph 53, or page 53 to, 53, 54, 55, 56, 57, and you can read that in due course. But I just wanted to draw your attention in relation to the construction contract, because that's another issue that was raised in the amended terms of reference. On page 56 of the submission, there's a reference to the construction contract. If I can invite you to look at paragraph 137 of the submission. So paragraph 137, on the 7th of July 2015, Curtin Brothers submitted a tender bid for construction of future works, and the price for the tender was about $269 million. And the tender included that CBPNG was an experienced and well-recognised civil and construction company, of course, and has considerable experience, and you can read that in paragraph 137. What is important is paragraph 138, because there was an evaluation of all the tenders, and you see that in paragraph 138 of our submissions. And there were a number of different contractors who tendered, and a score was attached to each of the tenders bids. And we see that in paragraph 138E, Mr Commissioner, and you will see that Curtin Brothers PNG Limited was ranked as number 1 in the process, and it received the highest ranking of points, received 270.4 points. And there was a proper evaluation process. And Mr Commissioner, you can see that when you read paragraph 138 and following. And the NEC and ports considered the various tenders, and it was decided in the end that they should succeed. There were other tenders like China Harbour Engineering Company and other companies. Some were far more expensive. Curtin Brothers quoted 244 million. There was one tenderer, if you look at page 59, Mr Commissioner, of the report, page 59 and little e, one tender actually quoted 706 million for the job, as opposed to Curtin Brothers 244. You see that on the bottom of page 59. You'll see in a table. So, Mr Commissioner, we deal with the contract in relation to the works on page 60, and then could I invite you to look at page 61, please. Page 61, paragraph 144.
Yes.
You'll see that on the 17th of March, this is in relation to the construction contract, the state solicitor, by letter to the Secretary of NEC, provided an opinion, and the opinion was that finance documents were in order to legally affect the transaction, and there was no unusually materially adverse obligations imposed, and he gave legal clearance. So he gave legal clearance earlier in relation to the port sale agreement for the land, and then he subsequently gave approval in relation to the financing, in relation to the construction contract. And you will see that in relation to the port's annual report, operating plan, so I should just go back and emphasise 2 points in relation to Curtin Brothers' tender. Curtin Brothers' tender was firstly the lowest price, and secondly, it was the shortest duration to do the work. That is, it was able to do the work the most expeditiously of any of the tenderers. So they were two important considerations, obviously, and they had a track record, as evident from their proposal, in relation to construction in PNG and major projects. If I could invite you to look at page 62, that the 2020 annual operating plan of PNG Port stated, after commencing at Motukea in 2018, benefits are already being enjoyed by vessel operators and importers alike through increased efficiency and faster vessel turnaround, combined with reduced truck waiting times in Port Moresby and Lae, and for international international container traffic. Could I now take you to a different section, but before doing so, I just want to re-emphasise that a proper consideration of all that documentation, the NEC decision, the Ports Authority, show that it was a carefully considered decision to purchase the land. Other options were considered, but ultimately it was considered that this was the most viable and best option. It was not the only option that was looked at, but at the end of the day, it was decided, soundly based, that this is the option that should be adopted. Could I now turn to the important evidence of the Prime Minister, Mr Commissioner, page 63 of our submissions. I should say at the outset that there is no contest to the evidence of the Prime Minister, Honourable Marape. His evidence is fully supported by the documentation which in part he supplied, and documentation which in part has been supplied to the Commission under summons or supplied to the Commission by other means. The Prime Minister said, and I quote, paragraph 148 of our submissions, NEC was impressed by the offer, and in the subsequent NEC decision in 2014, several decisions were made by Cabinet to realise the Motukea land deal. If I pause there, we have referred you, Mr Commissioner, to numerous NEC decisions which are consistent with the statement of the Prime Minister. That is, it was considered by Cabinet, it was decided to purchase the Motukea land, and it was considered in a number of different decisions, and there were subsequent decisions after the purchase to enable the transaction to proceed and be consummated. In paragraph 149, the Prime Minister's evidence also supports the following. A, he was entrusted with powers and duties under Section 46B of the Independent Business Corporation of Papua New Guinea Act. And B, on the 28th of August, was asked by the Managing Director of IPB to sign, and did sign the same day, approval for the PNG ports and the IPBC to execute a letter of intent, and subject to the conditions precedent, the port sale agreement for the purchase of Motukea for the price of $725 million. So he was asked to and did sign consistent with the decisions of the NEC to proceed at a price on behalf of the government of $725 million. C, paragraph 149C, he provided a letter dated the 29th of June to BSP in connection with $800 million loan provided to facilitate the funding. In the letter, the Prime Minister, then Finance Minister, stated in Section 2, and we quote, "The transaction is viewed as key to the economic interests of the state and the development of Port Moresby, and for this reason the state has requested the provision of a financial accommodation and has agreed to provide the guarantee and indemnity." Well, what do we say that the Commission should find in relation to conclusions to be drawn from the Prime Minister's evidence? We say they are set out in paragraph 150 to 157. The evidence supports you, Mr Commissioner, making these conclusions drawn from the Prime Minister's evidence at page 64. Supported by the fact that his evidence was totally consistent with the other evidence before the Commission. We say, Mr Commissioner, that the Prime Minister's evidence includes the following facts. Firstly, the Prime Minister was part of the NEC which made the decision in 2013 to relocate the Port Moresby Port to Motukea Island, considered that Motukea had the necessary wharf infrastructures in place, was impressed by the offer to sell, and importantly, in June and July 2014, made the decisions to realise the sale of Motukea, including initially approving a purchase price of $750 million and then approving the port sale agreement and the sale price of $725 million. Of course, that decision was made in the context of not having to rely on any valuation from the Valuer General, because they already had sufficient information to make an informed decision. The Valuer General's valuation had no impact in relation to this transaction. As it transpires, it was irrelevant whether it was 418 million or 722. It had no bearing on the decision-making process. The 418 million valuation finds its way nowhere, not to be found, not to be seen, in the thousands of pages of documents which have been produced to the Commission, except for the affidavit of Mr Gabriel Michael, more recently filed. And as we'll come to, the 418 valuation was never prepared when he said it was prepared. It wasn't prepared before the 722 million valuation. Importantly, we say that in 151C that the Prime Minister, as then Finance Minister, correctly provided the required approval under Section 46B to enter into the PSA and the letter of intent. And indeed, the Prime Minister, as then Finance Minister, approved the execution of the letter of intent and the port sale agreement for a price of $725 million, thereby allowing the transaction to proceed. In paragraph 152, we make the observation that these facts are directly from the evidence provided from the Prime Minister and are not contradicted by any other evidence. They are consistent with the other evidence, and the above facts should be accepted by the Commission of Inquiry and noted when writing the report with respect. We make this observation in paragraph 153. The Prime Minister was given ample opportunity with respect to prepare his affidavit. His summons was adjourned many times. There's no suggestion that the Prime Minister's evidence, nor could there be, that it was not carefully considered by him. He carefully considered his evidence. The Prime Minister was aware of the amended terms of reference, obviously, because he signed them. On the 8th of November, we say this in paragraph 156, on day 52 of the hearing, Mr Guerrero asked the Prime Minister if he had anything further he wished to add to his affidavit, of which his response was, "Everything I need to say is wrapped in my affidavit and it's for this inquiry." So he said everything that he wished to say. He said things which were consistent with the documentation, and his evidence should be accepted. And his evidence supports the sale price of $725 million being an appropriate valuation. It supports the fact that the transaction complied with all relevant laws and that the sale should have proceeded. And he was, with respect as Finance Minister, part of that process, and due process was followed. We deal in paragraph 158 and following with the misconceived and leading question put, we say unfairly, to the Prime Minister. The summons provided and asked the question if such other relevant evidence as may be required during the course of the hearing of this inquiry. That opened up the prospect of the Prime Minister saying whatever he thought was necessary or relevant to any of the terms of reference. And he was also invited by the oral question. And he restricted himself quite properly to the evidence that he was aware of and stated his conclusions and the facts. The Prime Minister didn't answer that question as referred to in paragraph 159. Instead, the Prime Minister was provided with a copy of Mr Michael's affidavit. He wasn't provided with an affidavit, as we understand, with an affidavit from Mr Kitterpat. He wasn't asked any questions about whether someone would be sacked or not for not doing something. Having said that, he was given a copy of the affidavit and he restricted himself to things that he had knowledge of. But in paragraph 159 we say the question was whether or not the Prime Minister would, with the benefit of knowledge of this previously undisclosed false valuation, have still given the statutory approval for the transaction. The false valuation, of course, refers to, as labelled by Mr Michael, the $722 million valuation. At the time the question was asked and answered, there was still an issue, and there still is an issue, about whether the valuation is false or not. Of course, Curtin Brothers and Balimore say the valuation of 722 is not false, and in fact was relied upon by Mr Gabriel Michael, as we say, in March 2015, for the purposes of the comparative value for other land. Despite it being a misconceived and legal question, the Prime Minister said, "I cannot answer this as I do not have knowledge of the undisclosed fact at the material time." We say that at paragraph 161. What really needs to be done and what the Prime Minister would need to do, which the Commission now is required to do, is evaluate carefully all the evidence. Okay, all the evidence. That was simply a leading question and an unfair question to the Prime Minister, because there needs to be evaluation of all the evidence relating to that issue. Importantly, the Prime Minister was a member of the NEC that approved the port sale agreement with the purchase price of $725 million, and the Prime Minister correctly acknowledges that. May we now invite you to look at a separate subject, naming Mr Gabriel Michael's evidence, and we address that commencing at page 67 of the report. Do you have page 67, Mr Commissioner?
Yes.
And we say, in accordance with natural justice and procedural fairness, you're required to consider all these submissions and evaluate them when making your report, because we say if one notes the submissions and properly evaluates them, the conclusion must be that Mr Gabriel Michael is not a credible or reliable witness, and you can't rely on his evidence. At a high level, we know that it's inconsistent with Mr Kitterpat's evidence at a high level, but as we will demonstrate, his evidence and his reliability is weakened, in fact materially weakened and made redundant by a careful consideration of his inconsistent evidence, contradictory evidence, and the documentary and other evidence. When he gave evidence, and we make this point in paragraph 164, when he gave his oral evidence, he wasn't asked to state his recollection of events. which would normally be expected to test his reliability as a witness and test his memory. What happened to him was that he was simply asked to read out parts of his affidavit. That's not proper examination with respect of a witness, because you can't test his evidence properly, because all he's doing is reciting something that had been written and not asking him to test his memory to see there were inconsistency between his oral evidence and his written evidence, particularly in relation to a transaction that happened so many years earlier, and a transaction and alleged meetings where he has no record, no diary note, no email recording this meeting, no complaint to anyone about the meeting, nothing. He doesn't have one single document to justify this meeting or what was said at this meeting. Not one single document. Yet he said it was such a critical meeting, and he thought if he didn't do something he might be sacked, and he talks about a false valuation. That, with respect, doesn't have credibility when carefully considered and fairly evaluated. Mr. Commissioner, we adopt your words with respect, set out in paragraph 165 of our submissions. On day 53 of these hearings, you said, and we quote at paragraph 165, I know there's conflicting information on a certain statement that has been adduced to the Commission so far, but the question that the Commission will now raise is, are these statements follow the criteria of truth that we need to come up with? And I'm very concerned about the way the Commission is addressing issues, because based on the extended terms of reference and the questions that have been raised, quote, we need to provide proper evaluation and proper examination on the statement. And that proper evaluation and proper examination, as we've said several times, requires a proper evaluation and examination of not only Mr. Michael's evidence, but compared to other evidence. And you also correctly said, with respect, as we set out in paragraph 166 of our submissions, on day 54, I know that when we are closing in to complete this inquiry, our thoughts must be very clear, and the statement that we make must be clearly verified, so that we don't have any issues that are going to be left that we have not dealt with. That is the position of the Commissioner, the Commission, clearly verified. So in the case of Mr. Michael, it should be verified by other documents. Any meeting and the contents of any meeting should be verified by contemporaneous documents, that is, documents that were prepared at the time. But he does not verify them at all. No verification, Mr. Commissioner. So he fails the test, Mr. Commissioner, that you have correctly stated is the position. He has failed the test. And when we go through his evidence, not only will we demonstrate that he has not fairly verified this matter, but he has contradicted himself in material aspects. He is self-contradictory, self-inconsistency. We deal in paragraph 168 with the issue, the fact that Mr. Michael was not cross-examined does not mean that his evidence can be accepted, nor should it be accepted without question or evaluation. And we made the observation earlier in our submissions that you, Mr. Commissioner, raised the issue about no cross-examination, and we responded to that in our earlier submissions, but I'll reiterate some of the matters in paragraph 169. The fact that a witness is not cross-examined does not make otherwise false evidence or unreliable evidence somehow true or reliable. It remains false or untrue or unreliable. Let me address that in more detail. Paragraph 170. We say, first, as confirmed by counsel assisting at the hearing, Mr. Michael Summons was discharged on the basis that it was understood that we would make submissions in relation to the unreliability and credibility of his evidence. And consistent with that, we do so in this submission. In paragraph 171, secondly, we say where a witness is not cross-examined, the evidence should be rejected if it is unreliable, contradicted by other evidence, or other circumstances support its rejection. And that could include the failure of a witness to verify, the other circumstances could include the failure to verify a person's position. If they don't verify, it could be unreliable generally, it could be contradicted by other evidence, which will establish, or it might have other circumstances, including a lack of verification. A witness may include an obvious lie. We give this example in 172. A witness may include an obvious lie or say something that is false in their evidence. Even if not cross-examined on their evidence, it does not mean that the lie or false statement can or should be accepted as true. For example, a witness may state that his or her age is 21 when it is obvious that that is not true from other evidence considered, including a birth certificate or evidence from another person. It may also be contradicted by evidence of that witness themselves. The fact that a witness is not cross-examined does not make evidence that is false or unreliable all of a sudden become true or reliable. Let me give another example, Mr. Commissioner, which we do in paragraph 173, and one that applies to Mr. Michael's evidence. A witness may state in an affidavit that he has been willing to create false documents and certify them as correct. Even if not cross-examined, any witness that on his own evidence admits to such conduct should be regarded as unreliable, and their evidence should not be accepted on face value without question. The same applies where evidence from a witness is contradicted by other documentary or oral evidence or is inconsistent with the witness's evidence or other documents that they have produced, as in the case of Mr. Michael's evidence. At the top of page 69, we submit that the contradictory or inconsistent evidence means that even if a witness is not cross-examined, it should in the normal course be found that the witness is unreliable or not credible, and their evidence should not be accepted on face value and without question. It must be properly evaluated and examined. We now deal with the summary of why Mr. Michael's evidence is not credible and should not be relied upon. This is a summary, and then we go through and properly evaluate in more detail. First of all, paragraph 175, we draw your attention, Mr. Commissioner, to Mr. Michael referring to two valuations. The valuation report annexure G to Mr. Michael's affidavit with a valuation of about 418 million and another valuation of about 722 million. He produces two valuations. We say in paragraph 176, when a proper evaluation and examination of his evidence is conducted, together with other evidence, for the reasons we explain, the Commission inquiry should find that Mr. Michael's evidence as the 722 million valuation being false or caused by pressure is not credible and should not be relied upon, as his evidence on this issue is unreliable and inconsistent. It is unverified. Following is a brief summary of this submission. Paragraph 176A. We need to look at the context of Mr. Michael's valuations. A valuation by the Valuer General was not required by law for the transaction to proceed, and the NEC did not in fact take the Valuer General's valuation into account when negotiating an agreeing the ultimate price of 725 million. That's apparent from the NEC documents and other documents we've taken you through this morning, Mr. Commissioner. Therefore, whether the 722 million valuation was false or not was irrelevant, as the NEC's decision to acquire Motukea at the price of 725 million, it made no difference to the purchase price. In 176B, referred to Mr. Michael's evidence not being credible, so we draw your attention to a number of matters. Mr. Michael was not some junior public servant. He was the Valuer General for the independent state of Papua New Guinea. He was in a senior position. He had significant responsibilities to the state. He was subject to legislative code of ethics. But if he did, as he more than 7 years after the event now says he did, certify a second 722 million valuation is correct, when on his evidence he says he knew it was false, then he has demonstrated on his own evidence, Mr. Commissioner, that he's been prepared to act dishonestly, and therefore his evidence cannot be relied upon as having been given by an honest and reliable witness. he certified 2 separate valuations as true and correct, under seal. Secondly, no other evidence before the Commission inquiry challenges the validity of the 722 million valuation, and accordingly, the 722 million valuation should not be found to be false. Thirdly, as we say at the top of page 70, the suggestion that Mr Michael could have perceived that his position was in jeopardy should he not produce a higher valuation of Motukea than the one he says he had produced is uncorroborated by any other documentary or oral evidence. It's not verified by any other evidence. It's contradicted by Mr Kitterpat's evidence, and it should not be accepted by the Commission inquiry. In C, on page 70, we submit that the 418 valuation was most likely produced after the 722 million valuation, calling into question the existence of the 418 valuation at the relevant time and the reliability of Mr Michael's evidence generally, and we'll take you through in more detail and do an analysis of both valuations to demonstrate that, Mr Commissioner, on a proper valuation, you could not accept his evidence that the 722 million valuation was produced second in time. It's inconsistent with the documents he's produced. Indeed, we say there's nothing improper in a valuer revising a valuation, including after discussions, if there are any, with representatives of property owners. In E, Mr Michael relied upon, this is important, the 722 valuation as a, quote, very good comparable, in his words, a very good comparable, when valuing the Port Moresby main wharf in March 2015, indicating that he did not consider the 722 million to be false or inaccurate. In other words, what happened was this. He prepares a 722 million valuation in September. He says that he previously produced a 418 million valuation and the 722 million valuation is false. We will demonstrate that that can't be accepted. But if you just accept it for the purposes of argument, he then says that in March 2015, 6 months after he says he produced a false valuation, he relied on a figure of 722 million kina as a comparable value of land to value another property. If he was truthful in what he says to the Commission, he would not have relied on the 722 million valuation or value in March 2015 when he signed, sealed and certified a subsequent valuation in relation to another property. If he was true to his word, complied with his obligation, complied with the Code of Conduct of our General, he would have had to apply the 418 million valuation, but he didn't. He chose that an appropriate value was 722 million as a comparative value of land. Indeed, we say there is nothing improper, in G, the qualified Deloitte valuation and Ernst & Young valuation are above 418 million and recognise that the value of Motukea was likely to be higher, taking into account factors which they note in their reports. The Deloitte valuation and the Ernst & Young valuation are not inconsistent with the 722 million valuation. And that's where a careful analysis of their valuations is important. If one just takes a cursory look, a superficial look at their valuations, one might think that their valuations are less than 722 or the land is worth less than 722. But when carefully analysed, and we'll take you in detail to it, Mr Commissioner, and carefully analysed, they don't support the valuation not being attributed at 722 million. In fact, they reinforce it for reasons which we'll explain. Mr Commissioner, I'm not sure whether you wish to take the luncheon adjournment now or what you wish to do.
Sorry.
Or whether you wish to continue. I'm happy for it to be adjourned or continue. It's up to you, Mr Commissioner, to direct what you want to do.
Council.
Commissioner, I think we're halfway through the submissions. Would propose to continue through to the end.
Adjourn.
Continue the submissions.
Okay.
It's up to you, Mr. Commissioner. I'm happy to continue or
When do
adjourn,
you want us
whatever you
to
decide.
come back to complete this?
You want to complete it, Mr. Commissioner?
You want us to continue?
I'm happy. Sorry, Mr. Commissioner, I'm happy to either have an adjournment or continue, whatever you decide.
Sorry, Councillor.
Like I said, we propose to continue with the submissions, sir.
Sorry?
Continue with the submissions, thanks.
Yes, Councillor Varitimos, you can continue. We need to complete this.
Okay, thank you, Mr. Commissioner.
Yes.
If I could turn to page 70, the context of Mr. Michael's valuations. If I could invite you to look at page 70 of the submissions.
Yes.
Paragraph 177, we say that the 418 million valuation and the 722 valuation must be considered in context. This is at page 70.
Yes.
I'll let you find page 70, Mr. Commissioner, so you can follow it. I'm referring now to paragraph 178, 70. First, there was no legislative or statutory requirement for evaluation by the Valuer General. It was not required by law for the transaction to be valid. That's the first thing. Secondly, evaluation of the leases and assets of Motukea being sold only occurred due to it being included as an optional requirement in the and that was included at the request of the state solicitor. It did not make the valuation a mandatory requirement, and the relevant clause provided that the valuation certificate was only to be obtained, quote, if required. As a matter of law, there was no requirement, and there's no evidence from the state solicitor that the valuation certificate was a mandatory requirement. Paragraph 180, we say, thirdly, the valuation of Motukea by Mr. Michael occurred in September 2014, but it was after the state team, chaired by the Chief Secretary, had already formed the view to negotiate the purchase of Motukea. The parties had already negotiated a purchase price of $725 million. The NEC had already approved a purchase price of $750 million. The IPC had implemented an environmental and social impact study. In E, the project steering committee had been formed and considered Curtin Brothers' offer of $800 million. There had been independent qualified valuation from Deloitte and Ernst & Young, and that the NEC had already approved the execution of the port sale agreement, which included a purchase price of $725 million. In paragraph 181, we say, fourthly, the letter from the state solicitor providing legal clearance on the 25th of February made no specific reference to the Valuer General certificate or valuation. In 182, we make the submission that this context is critical in understanding the role and any importance placed on Mr. Michael's valuation of Motukea. It should be found by the Commission inquiry that Mr. Michael's evidence, A, was an optional, not mandatory step. Valuation was an optional step. B, was completed after the purchase price of $725 million had been negotiated. And C, occurred after the price had been approved by the NEC and agreed to independently of any valuation. In 183, we say it should also be found, given the important context, that neither PNG Ports Corporation or IPCC or any relevant state relied upon Mr. Michael's valuation, whether 418 or 722, in deciding whether or not to purchase the property for 725. Section B on page 72, we deal with Mr. Michael's evidence not being credible. Mr. Michael's evidence as to the 418 million valuation being correct, the 722 million valuation report being prepared after the 418 valuation and being false, and the alleged pressure by Mr. Kitterpat, Mr. McGann, is not credible and should not be accepted. We say, firstly, paragraph 185, Mr. Michael was an experienced valuer required to undertake a valuation on behalf of the state. In 2014, when Mr. Michael valued the Motukea sale, he was the Valuer General of Papua New Guinea and had been employed with the Office of the Valuer General for over 20 years. He had conducted thousands of valuations in Papua New Guinea. He was an experienced person. He signed a certificate for $722 million that, in accordance with his quote, knowledge and belief, all statements and information in this report are true and correct. The idea that a person of his experience and in his position of important responsibility at the time would have intentionally provided a false valuation and false certification of such a significant transaction is not believable. If Mr Michael did produce, signed, sealed and certified as correct an intentionally false valuation, then he did so in contravention of his duties and role as an independent valuer and Valuer General, is therefore on his own evidence unreliable. We wish to draw your attention in paragraph 188 to the two valuations, Mr Commissioner.
Yes.
Paragraph 188, we have Annexure G and Annexure H, the two valuations.
Yes.
If you could open up the bundle of documents at page 108, Mr Commissioner, so if you could keep those submissions open and go to the bundle of documents we gave you this morning.
Yes.
So if you keep that submission open and go to the bundle of documents and turn to page, they're numbered at the bottom right-hand side. If you turn to page 108.
Yes.
You'll see that he says the fair value is 418 million in that report.
That's right.
And then if you go to page 122,
Yes.
you see there's a certification that he has. 16, it says certification. And it's under seal and under his signature. You see that, Mr Commissioner?
Yes, yes, right.
Yep. Now, we've sought to reproduce it, but it might be difficult to read on page 73. So on page 73 of the submissions, go to page 73,
Yes.
we've tried to set out, in relation to the two reports, the certification page or pages. And by way of comparison, if you wish to look at the other report, if you turn to page 128, turn to page 128
Yes.
for the bundle, you'll see that this is where the fair value is said to be 722 million. You see that? And you'll see again, it's said to be signed under seal, and the date of signing is said to be the 23rd of September. If you have a look on the right-hand side of page 128, the date is the 23rd of September as date of signing. If you then have a look at page 142,
Yes.
is a 722 million valuation. You'll see again, it has date of signing, 23rd of September, and it's signed under seal by the Valuer General. And if I invite you to look at paragraph 16 there, on page 142, he says, we quote, "We hereby certify that we have no interest present or contemplated in the property valued, which we personally inspected, and that in accordance with our knowledge and belief, all statements and information provided in this report are true and correct. All statements and information provided in this report are true and correct," which includes the amount of the valuation of 722. So on his own evidence, he says he's produced two separate valuations, said they're dated the same date on the face of the documents, when on his evidence they're not dated the same date, and he certifies two conflicting valuations as true and correct under seal. So on his own evidence, he contradicts himself and he destroys his reputation and he destroys his credibility. In paragraph 189, we say if Mr Michael is, turning back to our submission, Mr Commissioner, paragraph 189, if Mr Michael is, on his own evidence, a person who is prepared to sign, apply an official government seal and certify that the contents are correct in respect of evaluation of critical infrastructure worth hundreds of millions of kina, when on his own evidence the valuation was false, yet evidence must be considered not credible and cannot be relied on and should not be relied upon by this Commission. Paragraph 190, we say that further on his own evidence he signed and sealed two different valuations as having been made and signed on exactly the same date. Both the valuations say they were signed on the 23rd of September, when those valuations were made and signed on his own evidence on different dates. So on the documentary evidence, he represents that they were both signed on the 23rd, but in his affidavit he states he had produced two separate and contradictory valuation reports, that on the 23rd of September he completed and signed off on his evidence, the 418 million report. But then he says a day or two later, according to his affidavit, he was called by Mr Kitterpat and told to increase the value. And then he says that same day he met with Mr McGann, and then a day later he completed and signed the 722 million report. So we make the submission on page 74 that despite his evidence, both of the valuation reports from Mr Michael, signed, sealed by him and certified as true and correct, state they were made and signed on the 23rd of September. On his own evidence, this must be false. This must be false because he's now given sworn evidence contradictory to that confirmed that they weren't signed on the same day. One was signed a number of days after the other, according to his evidence. Yet on the face of the document, he says, he certifies that they were signed on the same day. So anyone getting those reports would think that they were signed on the 23rd of September, when he's given sworn evidence contradictory to that they weren't on the same day. Secondly, we say in paragraph 191 that the explanation by Mr Michael gives for providing the 722 valuation and for it being false is contrary to other evidence before the Commission and is not credible, and we will draw your attention to that contradictory evidence. Mr Michael states in his affidavit that the primary reason for the conflicting valuations, and we emphasise primary reason for the conflicting valuation reports, was due to pressure because he was in fear of imminent disciplinary action or losing his job. This allegation is not credible and should not be relied upon because, as we say in paragraph 192, amongst other things, it's contrary to Mr Kitterpat's evidence. Mr Kitterpat's evidence was that there had been no discussions with Mr Michael. B, Mr Kitterpat was Mr Michael's boss at the relevant time, and he confirmed correctly that there was no way the Valuer General could have been disciplined or lost his job by not increasing the value. According to Mr Michael's allegation, the valuation produced out of fear is not credible. C, Mr Michael alleges that Mr Mann made aggressive demands to increase the valuation. However, he provides no details, but merely makes an assertion that some unspecified demands were made aggressively. His allegations are vague for what he alleges is an important event, and lack of detail undermines the reliability of his evidence. He has no documentary evidence, no diary notes, no emails, no letters of complaint, nothing to verify this meeting and what he alleges was an important meeting. Indeed, we say on 192, it is illogical to suggest that Mr McGann, Balimore, Curtin Brothers had any potential influence over Mr McGann's employment, Miss Michael's employment when being disciplined, and there's no evidence for the Commission inquiry to suggest they did. They were not his employers. They were not his employers. Yet he says he was in fear of them. It's a ridiculous proposition, Mr Commissioner. On page 75, under section 39 of the Valuation Act, the Valuer General was subject to a code of ethics for valuers. A code of ethics, Mr Commissioner. To produce a false valuation would be in breach of the Code of Ethics and Evaluation Act. There is no credible reason why Mr Michael would risk losing his job by producing a false valuation. Mr Michael makes no attempt to assist the Commission by explaining why the 722 million valuation is false. This makes his evidence unreliable, particularly in circumstances where he signed, certified, sealed a valuation as being correct and subsequently relied on that figure for a valuation of another property, which we discussed. It is noted that Mr Kitterpat, who unfortunately passed away prior to the conclusion of the hearing, gave evidence by his statement, and there's no good reason based on an evaluation of the evidence that Mr Ketterpat's version should be disbelieved. His affidavit with respect to the late Mr Ketterpat, there is no reason for you to cast dispersions on his reputation. His evidence should be believed, it's consistent with the other evidence, and it makes common sense. In paragraph 194, thirdly, there are no documents from the time of the events to support Mr Michael's assertions. As we've said, if Mr Michael's evidence that he produced the lower valuation and then with pressure to produce the high valuation correct, you'd expect as an experienced valuer, to have reported his concerns and to have kept a record of his conversations, but there are none. Not one single record, Mr Commissioner, to verify his version. On the 14th of February 2022, Mr Michael was issued and served with the summons, and we draw your honour's your attention to that, Mr Commissioner, in paragraph 195. Among other things, he was required to produce relevant documents, including minutes of meetings, conferences involving him and his officers, etc., and he's produced none. Of course, it's an offence not to produce documents that are relevant. He's produced none because he has none, Mr Commissioner. He has none. In 197, we make the submission tellingly Mr Michael has disclosed no diary reference, meeting minutes, file notes, or any other record of an alleged conversation between himself and Mr Ketterpat. Mr McGann respectfully, notwithstanding being served with the summons. So he has not one record, Mr Commissioner. He cannot be believed with respect in those circumstances. He is not a young graduate coming out of school, working in his first job. He's an experienced person. He should have records of any concerned conversations, meetings, etc. Yet he comes and gives evidence many years later that he had this conversation, and he tries to recount a story without the benefit of any notes because he has none, because if he had any, he would have been compelled to produce them. Paragraph 200, we say, fourthly, a proper examination and evaluation of both valuations shows that they were most likely not prepared in the order alleged by Mr Michael, and we will take you to that in more detail later. Mr Michael's affidavit states that on the 23rd of September, he completed and signed off on the 418 valuation, and then 2 or 3 days later, he completed and signed off on the 722 valuation. But as we have said, both valuations have a date of signing of the same date, the 23rd of September. Accordingly, on the face of each report, it is not clear which report was prepared first. Anyone seeing both reports would be completely misled. They would be misled because on the face of the documents, without examination, they give the appearance of being signed on the same date when they were not. And that's the danger of accepting at face value documents. It's the danger of accepting at false value the statements made by him. We say that a proper examination and evaluation shows that contrary to Mr Michael's evidence, the 418 valuation was most likely prepared after the 722 valuation. That is, he valued the property at $722 million, and then subsequently, at a later date, he produced what is in fact the false valuation. The 418 million valuation is the false valuation, not the 722 million. In paragraph 203, it's apparent that both reports have been typed using word processing software. Other than minor changes in context, both reports follow the same structure and have largely identical text. However, on a proper evaluation and examination, there are typographical errors that were in the 722 million valuation, which have been corrected in the 418 million valuation. Could we invite you to look at paragraph 203 and 204 of the submissions? So what happens is this. Mr Michael says that he produced a 418 valuation and then subsequently he produced a 722 valuation. But let's look at the documents let's look at page 204, paragraph 204 of our submissions. So the 722 valuation has on page 11 a reference to the direct comparison approach, and the depreciated replacement costs were used to derive values for the subject property. Now what we've done is in the two columns on page 204, on paragraph 204, we've compared extracts of the two valuations, the 418 valuation and the 722 valuation. When Mr. Michael prepared the 418 valuation, there was not a mistake in the paragraph that said the direct comparison approach. So the direct comparison approach you can see there, it's two words, comparison approach. When you compare it to the 722 valuation, comparison and approach are put together. There should be a gap between the two words. And then what he did, and then in the 418 valuation, the wording is correct. The land component and improvement wharf component were valued using the direct comparison, were, W-E-R-E. That's in the 418 valuation. In the 722 valuation, it's incorrectly spelled. It's W-A-R-E. Then also in the 418 valuation, he's put a comma after therefore, which requires a comma because it reads therefore, comma, in this valuation assessment, comma, we have. The comma, which should be included, is not included in the 722 million valuation. Now what he did was, he changed the value of the land in the 418 million valuation he had the 722 valuation first. It had some typographical and punctuation errors. 722 million valuation was produced first. It had some punctuation and spelling errors, which are identified, for example, in 204 in the 722 million valuation. He then produced a 418 valuation. So if you compare the valuations, which we can, you have a look at it, it's quite clear that it's a word processing job. He's basically changed the figure from 722 to 418 million. And when he did the second valuation of 418 million, he's picked up some punctuation and typographical errors. So he changed, which was incorrectly recorded in the first valuation, the 722 million valuation, he's changed W-A-R-E to W-E-R-E. So he's actually made corrections. He's made corrections, punctuation and spelling changes to the 418 million valuation. Now, it's not credible with respect that someone's going to prepare a report that has correct punctuation and spelling, and then goes subsequently and on a word processor makes deliberate mistakes in it and actually puts in spelling errors and punctuation errors. That's just not how it happens. So, Mr. Commissioner, let me just take you to the actual report so you can see what he's done. If I invite you to have a look at tab 3, page 118 and 119. Actually, I'll take you to page 108 first, sorry. Page 108 of the bundle.
Yes.
So you'll see on page 108, that's a reference to a total valuation of K 418 million. Page 108. You see that, Mr. Commissioner?
Yes, yes.
Then you turn to page 118.
Yes, I'm with you.
Number item 11, valuation methodology, towards the bottom. You see that?
Yes.
Item 11 on page 118. And it says there underneath it, the direct comparison approach. And you'll see that there's a gap between comparison and approach.
Yes.
You see that?
Yes.
And if you go to the next paragraph, you'll see that there's the correct spelling of were. The land component and improvement were valued using the comparison approach.
Yes.
You see that? And then if you compare that to if you go to page 138,
Yes.
or before 138, if you actually go to 127, you'll see that this relates to 128, you'll see that this relates to the 722 million valuation on page 128.
Yes.
And if you turn to page 138, under valuation methodology,
That is correct. Yes.
you'll see, Mr Commissioner, that it is a word processing job. When you look at the valuations, one's basically sought to look identical to the other, except for the figure. And you'll see under 11 that there are typo and punctuation errors. So it says the direct comparison approach and comparison and approach are one word, and the spelling is incorrect on the second paragraph where it says the land component and improvement wharf component WARE, W-A-R-E, value using the direct comparison approach. You see that?
That's right.
So, Mr Commissioner, we all know that when one goes to do a subsequent draft of a letter or whatever it might be, or an agreement, one corrects things. One doesn't go backwards and put errors in it. So it's just not feasible. He says he wants you to believe, Mr Commissioner, which is completely fanciful. He wants you to believe, it's fanciful on proper analysis, he wants you to believe that he produced the 418 million valuation first that had no punctuation mistakes or spelling mistakes, and then he produced a 722 million valuation by changing the 418 million valuation and deliberately putting in mistakes, punctuation and spelling mistakes. That's not what happened. That's not feasible. We know what's happened by looking at the documents. We know what's happened by evaluating all the evidence. What he did was he had a 722 million valuation, which is the only valuation that's appeared in the documents, apart from his 418 that's appeared in his affidavit. So he produced a 722 million valuation. It had some typographical and spelling errors in it. He then subsequently produces a 418 million valuation, changing that figure and picking up that he made some mistakes. So he changes the mistake subsequently. I think the point that I've made appears to be clear, Mr Commissioner, but you can read the submissions paragraphs 205 to 209, which seek to further explain it. But that remarkable change needs to be considered also in the context that he's produced no record to verify the meeting, no complaints of the pressure, etc. alleged. May I turn to section C on page 78? It is appropriate for a valuer to revise a valuation based on further information. And it's quite clear and consistent with Mr Kittapat's evidence and the Valuer General's Act that a valuer is entitled and should and is obliged to consider any further information that may be provided that may impact on one's valuation. And there's nothing untoward about that. We say the 418 valuation is not accurate, and we deal with that on page 79, section D. Independently of any other findings regarding Mr Michael's evidence, the Commission should find that the 418 valuation is not accurate. In paragraph 215, we say that the 418 million valuation report must be doubted because both the qualified Deloitte valuation and the qualified Ernst & Young valuation, which referred to in the project brief, letter of instructions and summary report provided to Mr Michael, valued Motukea at above 418 million. We say they're qualified because they didn't take into account, as they acknowledge, certain strategic values associated with the properties. In 216, we say that whilst the Deloitte and Ernst & Young valuations valued the land improvements at less than 725 million, those valuations are not and do not purport to be definitive valuations, both when one looks at them being subject to significant qualifications. The amounts in those valuations should be considered as starting points when one looks at them to value Motukea, with additions to be made for the qualifications listed in the report, and these are addressed in more detail. In paragraph 217, we make the observation that it suffices here to say, in respect to Mr Michael's evidence, that is set out in the brief to him prior to valuing Motukea, these reports, quote, did not include all key components of infrastructure, nor did the valuations, that is the Deloitte and Ernst & Young valuation, provide guidance on strategic value, and acknowledge that the valuations would be different from the transaction price. So the material that was given to Mr Michael highlighted that those reports didn't include key components of infrastructure and other matters, and they were a starting point. So we say the value of the land at 418 million is grossly undervalued. As stated above, Mr Michael's own brief made clear, that is the brief to him, made clear that the valuations of Deloitte and Ernst did not include key components and did not take into account strategic value. Paragraph 220, we point out that it was acknowledged by the NEC decision way back in January 2014 that based on the independent valuation, so this is important, the NEC had the benefit of the valuations of Deloitte and Ernst & Young, and they nevertheless formed the view that taking both reports on balance and providing some estimate of the strategic value, IBBC advises that negotiations can start at 700 million. And thirdly, it submitted that arriving at the valuation 418 million, Mr Michael cannot have taken into account the critical information included in his project brief. Mr Michael's project brief is set out in paragraph 222, and he was given important information, and he didn't take into account that information when he was preparing his valuations. Paragraph 222, some of the benefits of the acquisition are set out, which are included in his brief. And if Mr Michael had taken into account, as we say in paragraph 224, the matters that were briefed to him that were unique and significant benefits of Motukea, he could not have on his evidence and on the evidence of Deloitte's decision properly and accurately valued the Motukea Wharf at 418 million. Now, this is important, and it impacts his credibility yet again, Mr Commissioner, adversely. On paragraph 225 of our submissions at page 82, we point out that Mr Michael did not produce the Deloitte valuation and the Ernst & Young valuation, despite being served with the summons for him to produce all relevant documents. It's apparent from other documents and next to his affidavit that he was in fact provided with the valuations when instructed to value Motukea, but he did not produce them to the Commission of Inquiry. The Deloitte valuation and the Ernst & Young valuation, properly evaluated, undermine the reliability of his valuation. This is further reason to find that Mr Michael's evidence is not credible or reliable. We say that the 722 million valuation is more accurate, and we address that in section E of our submissions on page 82, Mr Commissioner. The Commission should accept that the 722 million valuation of the Motukea sale as being more reliable and accurate than this 418 valuation, which we say you must inevitably find was created after the 722 million valuation. In any event, as referred to, the NEC had resolved before any valuation of Mr Michael in September to execute the agreement on the basis of a purchase price of 725 million. The higher valuation more accurately reflects the immense value to Papua New Guinea and the greater public interest of the acquisition of Motukea. The policy submissions acknowledge the benefits. When all the relevant factors are taken into account, it's quite apparent, consistent with the NEC decision, that this property was worth at least 725 million. In paragraph 232, we draw attention to the basis of valuations. The correct value of the land and assets of Motukea is, quote, the estimated amount for which a property should exchange on the date of valuation between a willing buyer and a willing seller in an arm's length transaction after proper marketing wherein the parties had each acted knowledgeably, prudently and without compulsion. So the amount that you might pay for a property, Mr Commissioner, might vary to what someone else might pay. The next door neighbour of a property might want to pay more money for the property than you might wish to pay, where you don't own the adjoining land. This had a particular value to the independent state and the people of Papua New Guinea. It was a unique property, and in terms of this quote, it was a willing buyer and there was a willing seller at an arm's length transaction. And they were all acting knowledgeably, prudently and without compulsion. That's apparent from the long history of the transaction. We say on proper analysis the 722 million more closely reflects the accurate value of the land and the property. We have made a submission, and this is important, on page 84, paragraph 239. Could we invite you to look at page 239, paragraph 239, page 84, Mr Commissioner?
Yes.
This is page 84 of the submissions. Not the bundle of documents, the submissions.
Sorry, page what?
84 of the submissions,
Okay.
of the written submissions. I think you're looking at the bundle, Mr Commissioner.
Yes.
Page 239, paragraph 239 of the submission, page 84.
Okay.
Paragraph 239. We point out that Mr Michael did a valuation report of the Port Moresby main wharf, not the Motukea Wharf, with a valuation date of 12th of March.
Yes.
It's on page 84. That records that in determining the market value of that land, Mr Michael relied upon a valuation of Motukea at 722 million or thereabouts. Could we invite you to look particularly at paragraph 240 of the submissions, 240 of the submissions, page 84 of the submission.
Yes.
I need you to look at this if you don't mind, Mr Commissioner. Paragraph 240.
I'm with you.
Okay. Do you see there's a coloured yellow highlighting in paragraph 240? Do you have a yellow coloured highlighting, Mr Commissioner?
Yes.
Yeah. So this is an extract from page 9 of another valuation, which was certified by Mr Michael as true and correct and signed under seal. You'll see that it's under a section market value of land. Due to the unavailability of recent comparable sales in the vicinity of the subject, the following sales comparables were used. Now, as you're aware, when a valuer does a valuation, he looks for appropriate comparables of land to try and work out a value. And in the valuation of this land, you will see that he refers in the yellow highlighting part that we've highlighted to Motukea Island, 722,227 million kina. You see that. So, Mr Commissioner, what he did was, 6 months after he did the earlier report that we say was for 722 million, he relies on that value as a value for a valuation of another property. But it's much worse than that. He certified under seal and signed that the report is true and correct. And in paragraph 241, in that report, he says this: the Lacron sale was 2 to 3 years outdated with smaller land areas and is at close proximity to the subject, while the Motukea sale is just a year ago, with bigger land area and at an isolated location approximately 20 minutes drive away from the CBD and the subject. Quote, we've underlined this, they were very good comparables and were used as a guide only to adopting the fair rate that was applied on the subject's dry reclaimed land area. So not only did he use it as a comparable, but he said it was a very good comparable. Now, if his evidence was to be accepted, which it shouldn't, he should have used 418 million as a value, not 722 million. So he undermines his own credibility, Mr. Commissioner, and that comes back to the pertinent words that you said right at the beginning of this inquiry. One must carefully consider and evaluate all the evidence. One must carefully consider and evaluate all the evidence. And when you do, and you scratch the surface of his assertions, it's full of rot. It's full of falsity. It's full of dishonesty. He has tried to mislead you, Mr. Commissioner. He has tried to mislead you. And you will, we're sure, properly evaluate all the evidence and the submissions we have made. Mr. Commissioner, in paragraph 242 we make the submission. If Mr. Michael considered the 722 million valuation to be false or inaccurate, he could and should have left this out as a comparative sale. Even if he didn't want to refer to it, he could have left it out, but he didn't. He deliberately relied upon it. And this notion and assertion of pressure in the absence of any notes is, with respect, not credible. He says that he was under pressure as a result of one meeting, which he has no diary note of, and he says in his affidavit he had no further dealings with Mr. McGann after September 2014, no further dealings, yet 6 months later, where he's got no association with Mr. McGann, under no pressure, he relies on the 722 million valuation. And that's not credible, Mr. Commissioner. We now turn in section F to the Deloitte valuation being a qualified valuation on page 85 of our submissions. So if I could invite you to look at page 85 of our submission, Mr. Commissioner.
Yes.
Paragraph 245.
Yes, I'm with you.
Actually, before I do, could I invite you to have a look at page 65 of the working documents? Page 65 of the working bundle.
Yes.
Now, if you go to, Mr. Commissioner, to page 54, the working bundle first, that's the front page of the valuation.
Yes.
So this is the market valuation with the emblem of the Office of the Valuer General on page 54. So the emblem is there. It starts off Office of the Valuer General Market Valuation Certificate and Report. See that? And it's prepared at the bottom for the Independent Public Business Corporation. You see that?
Yes.
And then on page 55, he comes up with the valuation. This is different property, and the valuation is dated the 12th of March 2015 on page 55 of the bundle.
Right. Yes.
Page 55 of the bundle.
Yes.
So you have the bundle or the submission, Commissioner?
Yes, I have it here.
The bundle of documents. And it had an Office of the Valuer General Valuation Certificate, and you'll see that's for a different property. But he says value of interest, the current fair market value. So he says the current fair market value there. And then on page 57, he starts the valuation instructions and the purpose of the valuation. On page 57, and then halfway down that page, it's got dates of inspection and valuation. Do you see that, Mr. Commissioner?
Yes.
Dates of inspection and valuation.
That's right.
And it says date of inspection 11th of March 2015 and date of valuation 12th of March 2015. So it's basically 6 months after his last alleged contact with Mr. McGann. Then on page 67, sorry, page 65. If I should look at page 65, you'll see under market value of land, you have that page, Mr Commissioner, top of page 65, market value of land.
Page 65,
And
yes.
you'll see there that he relies as a comparable sale in that table, 3 items down, a description, to the 722 million value. Do you see that there?
Yes.
It's in the 722. So, and then below that, he makes reference that he's relying on it because the last paragraph on that page, he says the downtown comparable sales also 2-3 years ago, one is in very close proximity with the other two being adjacent, etc. They are very good comparables. You see that? So he's putting forward an evaluation which he certifies because if I can take you to page 69 of that bundle.
Yes.
He certifies under seal and signs on the 23rd of March that all statements and information provided in this report are true and correct. And he's being asked to provide a valuation, which he does, and he bases it on 722 million, not on 418 million.
That's right.
Now, if I could invite you then to go to the Deloitte valuation, is a qualified valuation, page 85 of the submission, Mr Commissioner.
Yes. I'm with you.
In paragraph 245, we make the point that the Deloitte valuation estimates the total value at 490 million. But we say that this is significantly qualified and should not be relied upon as an accurate valuation. As we pointed out, the NEC actually had the benefit of the valuation when they decided to pay the 725 in any event. But we draw your attention, and this is again why not a cursory examination of evaluation is appropriate. First, the 490 million amount, if it is to be used, should be used as a starting point or base valuation, as it is well recognised in the material, including that report itself, that there should be additions having regard to the qualifications in the report, including what the strategic value. So the valuations didn't attribute any value for the strategic value. They were basically board accounting analysis without taking into account the obvious strategic value. In 247, we make the point that the valuation does not take into account the strategic valuation, and the NEC considered and assessed the merits of the valuation. And as noted by the NEC, the Deloitte valuation, the Ernst & Young valuation, was able to provide some guidance. So it used as a guide on the cost of infrastructure. However, some issues with key assumptions has meant that adjustments have had to be made. Furthermore, they deferred business and strategic value to be settled during the process of negotiation, taking both reports on balance and providing some estimate of strategic value. IPPC advises that negotiations can start at 700 million kina. So again, a cursory examination of the reports is not appropriate, and the NEC dug deeper than the face value of the reports and correctly attributed that there was a strategic value which hadn't been accounted for in the accounting reports. The valuation of Motukea in the Deloitte report would therefore need to be increased to take into account the strategic value and benefits. And in addition, as we say in paragraph 249 of our submissions, the strategic value of the purchase is also referred to in the project brief given to Mr Michael, and Mr Michael did not make reference or analyse a strategic value attributed. He ignored that issue, even though it was briefed in relation to that matter. The Ernst & Young report itself, where it is expressly noted that the expected transaction price will likely include, as we say in paragraph 249b, and we quote, a premium for the strategic value of the status of the existing lease at Motukea. In determining the value of Motukea, and specifically the strategic value, the significant benefits obtained by PNG in the acquisition must be considered, and these benefits were outlined in section 5 of the submissions, which include economic and social need to relocate the port, the social and economic benefits of urban redevelopment of the CBD, the tried and tested nature of Motukea being established an international port, and Motukea being privately owned and avoiding issues of tenure. In paragraph 251, we make the submission, the benefit of this strategic value to PNG Ports place it in a category of special purchaser, and this was acknowledged by the Deloitte valuation as set out in paragraph 251. In 253, we make the observation that further significant qualifications were outlined in the Deloitte valuation, such that the value of 490 million should not be relied upon as the actual full value of Motukea, and we set that out in paragraph 253 of our submissions. Thirdly, we say that the Deloitte valuation uses an asset basis method to value Motukea, when on the face of the Deloitte's own report, that method was acknowledged to not be appropriate and was called into question. We set that out in paragraph 254. Fourthly, we say on page 88, paragraph 256, that the method used by Deloitte as a cross-check is not an accurate comparison, and we set that out and the reasons for that in 256. 257, we say that in valuing the land component, Deloitte valuation uses sales that were not comparable, and Deloitte valuation acknowledges that none of the sales used by them were directly comparable, and given the unique characteristics of the subject property, they would expect a purchaser would pay a premium for the subject, and that is acknowledged in the Deloitte valuation itself, and we highlight that in paragraph 257. We say that sixthly, in paragraph 259, the valuation date of the Deloitte valuation is September 2013, but the agreement was entered into over a year later in October 2014 and completed in July 2015, when we know that valuation in Port Moresby were going up significantly. Seventhly, the Deloitte valuation relies heavily and adopts an opinion of M3 property report, and for the same reasons above, the M3 report is affected by the same qualifications. So we would say that on any proper evaluation of the evidence and report and the appropriate qualifications in the report from Deloitte, that the figure of 490 million is a starting point and not an accurate valuation. We now deal with the Ernst & Young valuation on page 89, Mr Commissioner. The documents provided to the COI by KCHDL include the valuation report prepared by IPBC. That valuation estimates a market value of 589 million. Of course, Mr Michael, who was subpoenaed to produce all relevant documents and was provided with this valuation, did not provide a copy of the valuation to the Commissioner. If he had, it would have completely undermined his reliance on a 418 million valuation. The valuation estimates a market value of 589 million determined using a depreciated cost basis and a replacement cost value of 618 million, but it's significantly qualified and cannot be relied upon as an accurate valuation. It is, if anything, a starting point. First, as we say in paragraph 263, this 589 million amount in the Ernst & Young valuation, if it is to be used, should be used as a base valuation with additions. 264 of our submission is important. The Ernst & Young valuation itself said this: the transaction price that Curtin Brothers will expect will likely be made up of DRC value of the subject assets plus a premium for the strategic value of the status of the existing lease at Motukea. In quantifying the strategic value, the IPC could have regard to the following: the time and cost saving of the Motukea Forwards. And they went on to say the saving in time and cost of not having to undertake these negotiations may represent the strategic value of the Motukea over and above the DRC valuation, etc. Secondly, and this is a very simple way to determine that the 589 valuation can't be relied upon, but only as a base. In paragraph 265, we draw your attention to the fact that the Ernst & Young valuation, prepared well before the land was sold, values a total 49.5 hectares. That is a smaller parcel of land that was actually acquired. So they valued 49.5 hectares at 608 million or 589 million, depending on the methodology. On a simple calculation, noting that the amount of land was 28% more than the land value, 28% more than the land value in their report. If you applied a 28% lift factor, that would get to a value, as we say in paragraph 265, of 755 million. Simple mathematical calculation. 755 million when they paid 725 million, and in circumstances where the report did not take into account the strategic value and other benefits which we've set out in the material. The purpose of the Ernst & Young valuation, we should also say, was not to reach a final value of Motukea. This is set out in paragraph 268 of our submission, but to justify the transaction, but was a preliminary valuation to assist IPBC to enter into initial negotiations, which they did. We say at page 90 of the submissions that the 725 million represented a fair value for the sale, and we set that out and the reasons for that in paragraph 270, which you can read in due course. But significantly, Mr Commissioner, the best value evidence of the valuation of Motukea, as we say in L on page 91, the best value or evidence of value is that which was actually negotiated and agreed between two arm's length parties. There were two arm's length parties that were involved in extensive negotiations over many years, and they resolved that the value for this unique property, this critical property, was 725 million. And that's the best value, because we all know, Mr Commissioner, that valuers can have debates about what they think a property is worth or not worth, and there's plenty of dispute between valuers. But at the end of the day, it's what a buyer and seller, after appropriate negotiations, is prepared to pay. And that's the figure that they arrived at. They came down from 800 million. They started at 700 million, and the state got to 725 million. On page 92, Mr Commissioner, changing the subject, section 9, we deal with Mr Andrew Arky's evidence, and you can read that in due course. But in summary, his evidence is largely irrelevant. He seeks to give legal opinions about matters which aren't within his province, and he gives opinions about acts of Parliament, one that aren't within his province because he's not, and it's not even appropriate for a lawyer to swear an affidavit, but the acts of Parliament he refers to weren't even in operation at the time, and he wasn't there at the relevant time holding the relevant position. So it's really an academic and irrelevant sideshow, his evidence with respect, and it doesn't assist the Commission. It's more likely to mislead the Commission because he didn't hold relevant positions, and he's talking about acts of Parliament that weren't in operation at the time. In item 10, page 94, we deal with historical land dealings, and you can read that in due course, but we emphasise this, Mr Commissioner, that term of reference 1DDD is extremely narrow. The Commission's power of inquiry is limited to its terms of reference. It can't go outside the parameters of its terms of reference because it will be acting ultra vires or invalidly outside the scope of its powers. If you look carefully at 1DDD, it has limited scope. It deals with historical land dealing from the time of acquisition of customary land up to the Motukea Wharf project. We set out the fact that this is not an appropriate forum to deal with issues of compensation or disputes between landowners in relation to customary land. That's for another place. And the terms of reference must be considered in light of the limited time available and the introduction of the objectives of the Commission of Inquiry and the statement of case not being amended to broaden the scope of the Commission of Inquiry to a general examination of landowner issues. You made an appropriate ruling, Mr Commissioner, on the 7th of March, and we set that out on page 96 of our submissions. Paragraph 299, you made an appropriate ruling. The landowners made oral submissions, most of which are objectionable, and they must be held as irrelevant, consistent with your ruling already. You made a ruling set out on 299, and this is not the forum, as we say, to deal with compensation issues, interfeasibility issues, proper ownership of land issues, etc. And what we do is, if you look at page 308 of our submission, Mr Commissioner, on page 98, we've sought to answer amended term of reference 1DDD, and we've provided a chronology that's relevant to that term in Annexure 1. So if I could invite you to please have a look at page 117 of the submission.
Yes.
You'll see that we've provided a chronology of historical land dealing on page 117 of the submission.
That is correct.
And you'll see we've got footnotes to every reference. So you can see the document or documents that will support. Just check that support the proposition. I'll have to just check something there, Commissioner. So if I go back then to the submissions, Roman numeral 11, no adverse findings should be made on page 99. If I could invite you to go to page 99. The background to the proposed adverse finding.
Yes.
You'll recall, Mr Commissioner, that Ashurst wrote various letters to Council assisting, confirming various discussions and confirming that in accordance with natural justice and procedural fairness, the Commission would provide a letter Ashurst highlighting potential findings, if any, adverse or prejudicial, in advance of any findings. And there's been confirmation that that would be done. And then subsequently what happened was certain undertakings were given, set out on page 100. And then ultimately, which is important, paragraph 314 on page 100, a letter was received from Mr Guerrero, as set out relevantly on page 314, that it may be possibly open to make certain adverse findings. 1, 2, 3, 4.
Yes.
Now, what we submit, which is important in paragraph 315, is that the letter did not suggest the findings should in fact be made, rather it was possibly open that they'd be made. However, that possibility would need to be tested against the proper evaluation of all the evidence and the detailed consideration of these submissions. And we say, without being critical of Council assisting, Council assisting has given the letter as he's required to do, and he has only said that there may be a possibility. But that requires a careful consideration of all the evidence. And after careful consideration of all the evidence, we say that those findings that were suggested may possibly be open, not that should be made, should in fact not be made. We also point out in paragraph 317 that Council assisting was requested to give confirmation of certain matters that weren't being submitted, and he gave that confirmation. As referred to in paragraph 317 and 318. And Curtin Brothers and Balimore have relied upon the accuracy of those confirmations and undertakings in terms of determining whether to cross-examine witnesses, pressing for production of further documents and preparing these submissions. as referred to in paragraph 318. Could we make this observation as we do in paragraph 320? This matter has been widely publicised. This inquiry has been widely publicised. It has a website up for the duration of the inquiry. It received publicity in the media. There have been numerous summons. And notwithstanding all that, the only potential adverse findings relate to a witness, Mr. Michael, who has discredited himself, not complied with his code of conduct, gave completely contradictory evidence, been prepared to sign and certify and seal documents which on his own evidence are false. One can't, coming back to the case authorities, make such adverse findings which are potentially very serious based on the unreliable evidence of one person who has no notes of any conversation and quite obviously has created a second lower valuation after he prepared the valuation of 722 million. We set out in paragraph starting at 322 why the adverse findings should not be made, and we deal with each adverse finding. But the first potential adverse finding relates only to Curtin Brothers Holdings. It doesn't relate to Balimore. So if you look at the letter, if I invite you to have a look at paragraph 314, Mr. Commissioner, of the submissions, paragraph 314.
Yes.
The counsel assisting refers to 4 paragraphs. Paragraph 1, Curtin Brothers did not obtain nor rely upon any independent valuation. And then paragraph 2 refers to Balimore. So there are 2 distinct paragraphs. One is isolated and contained to Curtin Brothers. The second one is similar, but it relates to Balimore, a different entity. Now, we've made the obvious observation that Curtin Brothers wasn't a party to any of the agreements. Curtin Brothers didn't sign the agreement for the sale and purchase, and it wasn't a party to any of the other contractual documentation. Therefore, it would be perverse and wrong with respect on proper analysis to make any adverse findings against Curtin Brothers. They are not a party to the contract. We say then, in relation to the second potential adverse finding, shouldn't be made against Balimore because Balimore was not required to obtain or rely upon any independent valuation of the wharf. It was the seller of the property. It didn't require any valuation. They could just decide that they'd accept $1 billion kina for the property, and if that wasn't accepted, bad luck, they didn't need a valuation. Or they could negotiate a price, which they ultimately did, Balimore, to 725 million. So there's no requirement on a seller to get a valuation. So that's misconceived. No requirement to get a valuation, whether independent or otherwise. Then, in relation to third potential adverse finding, we deal with that in paragraph 329. There's inconsistent evidence in relation to this by Mr. Michael himself, because that potential adverse finding is based on the affidavit of Mr. Michael. If you look at paragraph 332, we quote a paragraph from Mr. Michael's evidence that he says that there was pressure to bear to increase it by 849 million. But the third potential finding is based solely then on the evidence of Mr. Michael, and for reasons that we've stated in the submissions, Mr. Michael's evidence is not credible. So it rests solely, potential adverse finding 3, it rests solely and only upon his evidence, and he's discredited himself. So one couldn't make the finding on that basis. Mr. Guerrero confirmed that the only basis to make that finding is the evidence of Mr. Michael, and in fact it's not supported by anything else. So in paragraph 333, we make these submissions that Mr. Michael's evidence is not credible and should not be relied upon for a number of reasons, including firstly, on his own evidence he's unreliable in that he produced a false valuation and signed two separate valuations, allegedly on the same date, when they were not produced on the same date. Mr. Kitterpat's evidence, the late Mr. Kitterpat's evidence, particularly to the effect that he never had any discussions with Mr. Michael and that he could not have pressured him, as it's asserted, contradicts Mr. Michael's evidence and should be preferred. C, there are no documents from the time of the events which would be expected if the allegations were true to support Mr. Michael's assertions that he was pressured or that he provided a false valuation as a result of any pressure. D, a proper examination and evaluation reports shows they were likely not prepared in the order alleged by Mr. Michael, and that it's more likely that the 418 million valuation was prepared after the 722 million valuation, perhaps a matter of only days before he swore the affidavit. E, in any event, the 722 valuation is the more reliable and accurate valuation given the surrounding detail and information, and was subsequently relied upon by Mr. Michael in the Port Moresby valuation that I took you to about 15 minutes ago. Secondly, as submitted in paragraph 334, the third potential adverse finding, and Mr. Michael's evidence on which it is based, is that, according to him, the primary reason for the increase of the valuation, that is, the pressure was the primary reason. The use of the words in his affidavit, primary reason, suggests that there were obviously other reasons that Mr. Michael, on his version, increased the valuation. He doesn't say, based on this so-called pressure, I increased the valuation. He says the primary reason. So there are other reasons, and he hasn't articulated what those reasons are. There could be valid reasons why he agrees to 722 million valuation. In relation to the fourth potential adverse finding not being made, we deal with that starting at paragraph 336. We draw your attention to relevant principles in relation to such an allegation, and where the reputation of an individual or company is seeking to be impugned or may be impugned by findings, the standard of proof, the validity of the evidence, the strength of the evidence increases proportionately with the seriousness or gravity of the matter in question. And that's what the cases in Papua New Guinea and elsewhere say. So before one can make an adverse finding, serious adverse finding that will affect a reputation of an individual or company, one has to look at the probative worth of the evidence and properly and fairly evaluate. And there's a high hurdle to jump. The cases basically say it's a very high hurdle to jump in terms of the evidence that must be established and the strength of the evidence before one can make such adverse findings. In this regard, we assist you by referring in paragraph 339 to a quote from the former High Court judge in Australia, which is the highest court in Australia, equivalent to the Supreme Court of Papua New Guinea, in a royal commission in which he conducted. And at paragraph 339, we draw your attention to his quote, "The processes of a royal commission and hence the inquiry I've conducted are radically different from those of a court conducting a trial, but the essential point made that a conclusion that there might have been misconduct should not be reached lightly. It is undeniably true." It's undeniably true. So one shouldn't approach this matter under a misconception or a belief that one has to find something wrong. One has to approach the matter with an open mind and then, having regard to all the evidence, evaluate the evidence and come to a conclusion. And the common law establishes, the case authorities established over centuries, as set out in paragraph 340 of our submission, that there must be clear, cogent or strict proof is necessary where so serious a matter is to be found. The need for clear and cogent proof reflects the perception that members of society do not generally engage in the conduct that might be suggested. For the reasons we've articulated, the Commission inquiry cannot be satisfied that the required standard in relation to the fourth potential adverse finding has been satisfied. We deal with the reasons why the fourth potential adverse finding should not be made at page 107, commencing at paragraph 344. First, we say the fourth potential adverse finding is based purely upon the first three potential adverse findings, and for the reasons above, none of those findings should be made. They're dependent upon those three findings. In his letter to Ashurst, Mr Guerrero could find that any recommendation to the COI that it may be open to the COI to recommend the matters stated in the letter are restricted and contained to the first three potential adverse findings. We say in paragraph 348, secondly, the fourth potential adverse finding is based solely upon the discredited evidence, unreliable evidence of Mr Michael. In paragraph 350, we again reiterate that on Mr Michael's own evidence in respect to the valuation of a critical piece of infrastructure worth hundreds of millions of kina, he signed, sealed with his official seal and certified as true and correct what he says is a false valuation report, and signed, sealed two conflicting valuation reports as having been made on the same date, when on his own admission they weren't made on the same date. A further reason we say in paragraph 351 to doubt Mr Michael's evidence is that the events alleged to have occurred in September 2014, over 7 years before he swore his affidavit. Human memory is imperfect and a person's memories can be wrong. No one can have clear memories with respect of what was said or done 7 years ago, particularly in the absence of any note or recording of the meeting. The longer the period between an event and its recall, the greater the risk of someone's memory being wrong. And we quote the passage from Chief Justice McClellan in Watson's case in paragraph 351, where the Chief Justice said, and we quote at the top of page 108, human memory of what was said in a conversation is fallible for a variety of reasons, and ordinarily the degree of fallibility increases with the passage of time, particularly where disputes or litigation intervene and the processes of memory are overlaid, often subconsciously, by perceptions or self-interest, as well as conscious consideration of what should have been said or could have been said. All too often what is actually remembered is little more than an impression from which plausible details are then, again, often subconsciously constructed. All this is a matter of ordinary human experience. When the COI comes to properly evaluate and examine Mr Michael's evidence, it must keep in mind the significant risk that Mr Michael's recollection of events that occurred over 7 years ago is wrong. When Mr Michael's evidence is then also evaluated and examined with his own contradictory evidence and the evidence of the late Mr Kittipat and the contemporaneous documents and his own valuation reports, they do not support his version of events. In fact, they counter his version of events and make his version of events false, or some of them. Accordingly, Mr Michael's evidence, on which the potential adverse findings are solely based, does not enable the Commission inquiry to be satisfied of the required level of any potential adverse findings, let alone a finding as serious as that suggested as a possibility. When Mr Michael's evidence is properly evaluated and examined with the other evidence before the Commission, which contradicts Mr Michael's evidence, the fourth potential adverse finding can and should not be made, and the evidence is addressed in detail in section 8. Fourthly, the Commission inquiry should not be satisfied that the fourth potential finding should be made in circumstances where Mr Michael's valuation were not relied upon in the NEC's decision to enter the agreement or the ultimate purchase price. They had no influence. So in those circumstances, it would be erroneous and unfair to start making referrals when it had no relevance. In any event, it's been discredited, and we point out in paragraph 357 that Mr Michael considered the valuation was true and correct in 2015 when he prepared his subsequent valuation, and that in itself completely discredits him. There are so many different aspects, Mr Commissioner, when properly and fairly evaluating the evidence, that completely discredit Mr Michael's evidence. It's not just one instance, it's dozens of instances. He himself discredits himself. What valuer general would sign, seal and certify as correct? What truthful valuer general would sign, seal a valuation and certify it as correct, and then purport on its face to sign a conflicting valuation on the same date and sign, seal and certify that as correct, when on his own evidence he did not sign that document on that date? He actually backdated a document. On his own evidence, he backdated, Mr Commissioner, a document and signed and certified that it was correct. One couldn't possibly accept his evidence, and certainly not accept his evidence for the purposes of making adverse findings. We conclude that the Commission, in relation to the adverse findings, the Commission, as we say in paragraph 358, can only make the fourth potential finding where the COI is satisfied of each of the first three potential findings, and also given the seriousness of the fourth potential finding, that there is clear and cogent evidence. And the entire potential adverse findings rest solely and only upon the discredited evidence of Mr Kitterpat. What truthful valuer general, what reliable valuer general, Mr Commissioner, would sign a valuation in 2015 saying that $722,000 was effectively a good comparable figure for a valuation, and certify that as correct, and put that valuation up to be relied upon as he knew, if he didn't believe that figure to be true and correct? It's completely inconsistent with the notion that the 418,000 figure was a correct valuation. We turn now to page 110 of our submissions, dealing with submissions on term of reference 1E. And Mr Commissioner, we seek to assist you by dealing with the answers to term of reference 1D at paragraph 360 to 375. But what is clear with respect is that due and proper, in summary, legal and administrative processes were followed in relation to this transaction. You've seen by the evidence that there's a long paper trail of NEC decisions, of feasibility studies, of other studies, of careful consideration by IPVC and others in relation to this acquisition. And it was a carefully considered decision based on due and proper legal and administrative processes to acquire this property, $725 million. To assist the Commission at page 112, we deal with submissions on the remaining amended terms of reference, and we deal with each of those and the answers to those, which you can read in due course. But the rationale, and we deal with that on page 112, the rationale, starting at paragraph 379, the relocation, in summary, was that at a high level, prior to the acquisition of Motukea, and we deal with this at 380, it was obvious that from an economic, social perspective, the location of the port in downtown Port Moresby was untenable, and the port had to be relocated, and the moving of the port out of the congested Port Moresby downtown area would affect immediate easing of traffic congestion. That in C on page 113, Motukea represented a plausible and realistic option to expeditiously relocate the port, etc. It was going to save a lot of money, and it was much lower cost because it was an established port. and the Motukea site was assessed to be the preferred site, having regard to other potential sites based on environmental, social, technical and economic considerations. So, Mr Commissioner, you can read our responses to those questions in due course. In relation to how the contractor was selected for the work, could we refer you to page 115 of the submissions? Page 115, paragraph 319. We deal with the construction. It's page 115 of the submissions, Mr Commissioner.
Yes.
We deal with how the contractor was selected, and as we've said before, there was a selection process and Curtin Brothers were considered the best tenderers. They were the lowest price, they had considerable experience, page 115, and they could do the work in the shortest contract duration. In paragraph 401, we say that there should be no recommendations in terms of any illegal activities. If we go to, Mr Commissioner, page 119 of the submissions.
Yes.
Page 119 of the submission. There's annexure 2, which is a schedule, and we've set out a schedule in relation to documents that we've received and not received and date received. Importantly, we make the observation that council assisting undertook that if there were any documents that were adverse or prejudicial to my client, they would be produced. And the only evidence suggestive, at least based by council assisting submission, is the evidence of Mr Michael. There's no other evidence in any of the other documents. And we hold with respect council assisting to that undertaking in confirmation. Just a few matters. I may have incorrectly said the discredited evidence of Mr Kitterpat. Mr Kitterpat's evidence, late Mr Kitterpat's evidence, should be accepted, and it's correct that the evidence of Mr Michael has been discredited. Mr Kitterpat's evidence has not been discredited at all. It's not only unchallenged, but more importantly, it's consistent with the other evidence and it's common sense. The Commission of Inquiry in our situation does not need to find anything adverse necessarily to Mr Michael. It just needs to consider his evidence and confirm that his evidence is unreliable in all the circumstances and not credible, and it does not support the clear and cogent evidence required for any possible adverse finding. I'm not sure, Mr Commissioner, whether Mr Wood has something to say that I may have missed.
Thank you, Councillor Varitamus. Councillor Wood.
Thank you, Mr Vrinos, and thank you, Commissioner. Commissioner, can I ask you to go back to page 77 of our submissions where Mr Vrinos took you through an analysis of the two valuations in terms of the typographical and grammatical issues?
Yes.
Thank you. And at the same time, can I also ask you to go to Mr Kitterpat's affidavit, which is in the bundle of documents, and can I just ask that you can identify paragraph 27 of Mr Gabriel Michael's affidavit?
That's which page number?
In the body of the, maybe Mr Verigamos can assist me, but it's on page 4 of Mr Gabriel Michael's affidavit.
Yes.
Page 23, Mr Commissioner.
Thank you.
Page 23 of the bundle.
And can I ask you to confirm, Mr Commissioner, that you've got page 23 of the bundle? Thank you. So, in addition to what Mr. Brunemos has said, that if a person contends or goes on to say that their evidence is not unreliable or not inaccurate, so if they repeatedly maintain that position, well, we can look at other factors. And so, to give it, a practical example, in addition to those that Mr. Brunemos has already given, if we look at paragraph 27 of Mr. Gabriel Michael's affidavit, he says that on the 23rd of September 2014, he says, I completed and signed off on the first Balimore Motukea Wharf land valuation report. He says he gave a copy of it to Mr. Kilopat. Then he says, a day or two later, I was called up by the secretary, Mr. Romley Kilopat, to redo the first one. I was told to increase the value of the first valuation report. So he then says that in paragraph 30, that same day, I drove to Motukea and met with Justin in his Curtin Brothers office. During our meeting, Justin and I met alone. Justin stated the first land valuation report was too low and was not accepted by Curtin Brothers. And he says, Justin said it was going to be sold for more than $1 billion. And at paragraph 31, Justin then demanded that I redo the first Balimore Motukea land valuation report by increasing the amount of the valuation to around $700 million. Due to his aggressive demands, I said I would do so and return to my office. And he goes on to say a day later, in fear of imminent disciplinary action or losing my job, I completed and signed off the second land valuation report and provided a copy to the Secretary, Mr. Romley Kilopat. Now, if we look at the analysis that Mr. Brunemos took you through on page 77 of the submissions, that evidence there, so if someone goes on to always maintain that their evidence is unreliable or inaccurate, then we can look at other factors. That evidence is so clearly at odds with what Mr. Brunemos took you through on page 77 of our submissions, because what is clear is that from our own analysis is that the lower valuation was actually created after the higher valuation. So we know that by looking at the table where the typographical errors and grammatical mistakes have been actually corrected in the lower valuation. So that is clearly at odds with the evidence of Mr. Gabriel Michael. And if Mr. Michael says that they've been placed under duress with the threat of the loss of your job, and he goes on in effect to say that he's waited so long to tell the truth, our submission is that it's simply not credible to only rely on your two valuations before the Commission, but not provide any other diary notes, entries of records of conversations, etc. To put it another way, if you say that someone has made aggressive demands of you, then it's only human nature that you're going to provide all details leading up to the event. If we go back and look at what is really a very cursory summary in paragraphs 27 to 31 of the affidavit, it's very vague on the detail. It's very cursory. It doesn't go into all the details as you would expect about the matters leading up to the discussion with Mr. Kilopat or this so-called meeting with Mr. McGann. And also, it's critical that you would have language in the first person. In other words, if you were to give it any credibility for someone who says that they've been waiting for so long to put their side of the story forward, that you would have detailed conversations of Mr. Kilopat said this, I said this, Mr. McGann made these comments, and I said things in response. But what we've got here is a very convenient, in terms of what Mr. Gabriel Michael has done, is at best a summary of his version of events which cannot be accepted. It's condensed into literally 4 or 5 paragraphs of something that occurred so long ago without any direct conversation, without any substance, and cannot be accepted. And so we say, as Mr. Brunemos has said before, that it would not be consistent with the proper evaluation of the evidence, nor would it be fair, Mr. Commissioner, that you could make a finding that Mr. Michael was placed under any pressure by Mr. McGann or by Mr. Calapat. So it's really very important we submit, when you're looking at the matters and evaluating the evidence, that you do take into account paragraphs 27 and to 31 of the affidavit, and just see how at odds it is with our analysis on page 77 of the submissions, and very much the lack of detail for somebody who says that they've been waiting for over since 2014 to give their evidence, and it's just so clearly lacking in detail without any corroborating evidence. They are the issues that I'd like to raise as well. So thank you.
Thank you, Councillor Wood.
Thank you, Mr. Commissioner. So as we understand it, Council Assisting will make submissions next Friday, and we'll make submissions Tuesday week after that, given the Easter period.
Based on the undertaking that we come to agreement with, the Council Assisting will do the submission on Friday week, which is the 31st of March 2023, at the same time, 10 a.m. Council.
Mr. Commissioner, yes, that is correct.
We have no other matters to deal with this morning, is that right? Thank you, Councillor Varitimos and the Councillor Wood and your team for your submission. We await the response from the Council Assisting, which is Friday week, and then we'll return back on the 11th of April to deal with that. Once again, I thank you for your attendance this morning. It's quite lengthy, but we have gone through a lot of analysis that I was also looking for. But given the circumstances and the fact that surrounds it, we are waiting for the Council Assisting to give the response to that. And until we return back on the 31st of March at 10 a.m., as I said, you can now adjourn the hearing to next Friday, which is the 31st at 10 a.m. Thank you.